तो समृद्ध कुटुंब से
Yes, Ms. Establishment.
So I was saying, yes,
Notebook.
Your Lordship, that
Notebook.
the spoken or unspoken assumption is that Article 370 is temporary, lying in wait for a greater integration. I'm saying that that view is completely fallacious because integration is not a measure of how much control the center has.
What did you say at the end? Integration is not a measure.
It's not measured by how much control the center has. It is not a function of central control or power. And it would be pernicious to say that people in the union territory are more integrated than, say, people in a sixth schedule area. That's not how our democracy works, and that's not how we view people. So this assumption that Kashmir and Jammu were not integrated, even earlier, even in Iyengar's speech, the waiting is for accession, whether they ratify it or they don't ratify it. But once they acceded, they became Indians. And in fact, even before the Indian army, when the facts are this, even before the Sikh regiment reached Srinagar, it was the Kashmiris of the valley who fought the intruders, and many of them were martyred. Mir Maqbul Sherwani is only one name. He was strung up and crucified as an example by the intruders, hundreds of them.
Stop those people.
Yeah, he
Not cross over. I mean, it's heroism beyond belief. So we're not waiting for them to integrate anymore. Now, at the point of that, at the point of accession, aside from when the Maharaja yielded, how much sovereignty he retained, whether his pact is enforceable or not as a fact between two sovereigns of whom one was subsumed, is a different matter. I'm saying there's a democratic argument to be made of shared sovereignty. At the point of accession, because political sovereignty vests in the people of Jammu and Kashmir became sharers of Indian sovereignty as political sovereigns. And your lordships have recognized the theory that political sovereignty is entrusted to the legal sovereigns, and the constitution is an embodiment of that. And your lordships have recognized in the Indira Nehru Gandhi case that this legal sovereignty, it's a medieval concept to call it indivisible. It is essentially divisible. The nation state is an association of associations, and sovereignty, legal sovereignty, spread over various units. Of course, that case was considering the legal sovereignty as distributed among the three organs of the state. But the principle is equally applicable to the divided sovereignty between the center and the states. Because long ago, much has been said about the dual polity. I don't have to repeat it. So what Article 370 recognizes is this mode of government. It is the shared sovereignty of the people of Jammu and Kashmir, the merging of their democratic will with that of the rest of India. So in that sense, there is a democratic pact which has become part of Article 370. It has a constitutional recognition and guarantee. And that is quite aside from whether the Maharaja's pact with Mountbatten is enforceable or not. There is a democratic principle behind it. So in my view, Article 370 reflects and incorporates an entrustment of popular sovereignty to a divisible and shared legal sovereignty between the center and the state of J&K.
Just a second. Article 370 recognizes, can you come again on that?
An entrustment of popular sovereignty to a divisible and shared legal sovereignty between the center and the state of Jammu and Kashmir. And
Yes.
Yeah.
And just as integration is not synonymous with centralism, sovereignty is not the preserve of the center. Article 370 also reflects and recognizes the historical and geopolitical background of a democratic coming together of people's will. The will of the people of Jammu and Kashmir meeting the will of the rest of the Indians. It was really a democratic urge, and many have spoken about it, how they chose India over Pakistan, although they were not given the choice of a plebiscite. Even so, they chose a secular and democratic option. They said, here is a state which recognizes the sovereignty vests in the people. And also, as your lordship said in Indira Nehru Gandhi, that this shared sovereignty is really a system of checks and balances. Equally, it is so between the center and the state. So Article 370 also reflects a system of checks and balances, central power and the power of the state. State of Jammu and Kashmir. Because the people are never completely excluded from any process, although they have entrusted their sovereignty. This is what the judgment says. So the checks and balance system is what expresses the political sovereignty so that nobody encroaches. So Article 370, in that sense, the will of the people of J&K permeates every part of Article 370, 371, and 371 survives. It is not, I do not endorse the view that the whole article has come to an end. 371, the concurrence, and I'm not saying it's binding. What Iyengar's speech is certainly not binding, but it reflects the fact that despite there being a titular monarch, the power of concurrence, even when there was no state legislature, was given to the largest party because it was a democratic step. And that is why 371, both for concurrence and for consultation, the state government is emphatically defined as a governor advised by a council of ministers. Even the CO 272 says that. Whether by mistake or what, I don't know. So a governor who is not advised by a council of ministers is not recognized by 370. And therefore, any CO issued during a period of president's rule is simply not competent. Actually, I checked. In 70 years, all of 5 COs have been issued during president's rule or governor's rule. 1 in 1986 and 4 extending the term of presidential proclamation in the year between 90 and 96.
What's the number of the 1986 year?
129, CU 129.
And what was it relating to?
It was relating to, I think, the power under Article 249. It was a temporary resolution. And it was challenged, but it was never tested. What I want to say is this has never been tested for constitutionality. It was challenged in the Delhi High Court, but eventually it was dismissed as infructuous. So there is no ruling. So despite the peremptory terms of Article 370, whether a non-responsible government, a government not responsible to the state legislature, could exercise this power of concurrence has never been tested. And I'm saying it cannot be done. I could hand over the 5 COs instead. And therefore, Article 356, which is not covered by a non-obstantive clause, 370 is its special term, its sui generis power to the state government is a power. And it is not a function that can be taken over by the central government. Function is a duty. Power is a discretion. It's a sui generis power given to a responsible state government, and consciously given to a responsible state government. It cannot be taken over under Article 356, which is subservient to Article 370 on the sheer terms. And even a responsible state government's consent will not suffice for changing the terms of the article. It has to emanate directly from a constituent assembly. A constituent assembly signifies an exclusive agency, exclusively devoted and representative of the people of Jammu and Kashmir, fully and exclusively. So, if a change has to occur, it has to occur by an emanate. The recommendation has to emanate from an agency which is equal in mandate and stature to a constituent assembly. This is how the will of the people of Jammu and Kashmir, on a principle of shared sovereignty, is reflected in Article 370. And that agency, which must be equal, today there is no constituent assembly. After 57, there is no such agency on the horizon. If it has to be contrived, it will either be through political will, as they say, the hour, if I may paraphrase, the hour may produce the means. Else, whether it can be contrived in terms of the existing constitution, I do not think Article 368 will apply. Because the terms of Article 370 is this article, and Article 1 will apply. So the limitations are there in the article itself, but whether it applies or not, that's not what has been done. Some thought and sensitivity and democratic stirrings are required to think of an agency which could express this will. But one thing is clear, it cannot be any agency of the centre. It cannot be, because a democratic pact is between two power centers of sovereignty. And this is not as though they're setting up their wills against Indian sovereignty. As part of Indian sovereignty, there's a checks and balances system. There's the state and the center. So how can the center exercise the power which has been given to the state? It's, on the face of it, it's absurd. So the constitutional intent is clear. It cannot be any agency of the center. The will of the people of Jammu and Kashmir is integral to the mode of governance specified in Article 370. And a process which has systematically, with malintent, erased the will of the people can never legitimately affect Article 370. And their will has been systematically erased in this fashion. I quickly give the run-up. 20th of June, the governor's rule is imposed because and it is stated in the order that because one party has withdrawn and no other political party is ready to form the government. This is why governor's rule was imposed, not because of anything else, not because there was a security issue, not because the state was in any danger. Because no political party was willing to form the government, then what earthly reason had the governor to dissolve the House within 30 minutes of two agencies saying we are ready to form the government? Two political parties. One, a letter, it's what page is this? I'm not going to read it. Page in the petition compilation.
Mr. Sibal has already taken us.
Yes, I don't want to read it again. So 56 out of 87 MPs take a claim. The governor is not there. We cannot determine where the governor is, but we can inform him. It is on record that the secretary has acknowledged the WhatsApp message. He does not answer the phone, fax doesn't go through. He is informed on WhatsApp, and a public tweet tagging the governor is issued. By 8:16, this is done, and by 8:57, we are notified that the House has been dissolved. What earthly reason has a governor to dissolve a house when governor's rule was imposed only because no political party was ready to stake a claim? And when political parties are ready and willing to stake a claim, what business has the governor to say, I'm not here, I'm not there? Then in this state of affairs, there is a proclamation of president's rule, and the president usurps the power of the state government under Article 371. It is not permissible under Article 356 because it only allows him to take over the functions of a state government, not sui generis powers, protected by a non-obstant clause. And what need has a power? He has executive powers to do whatever has to be done on a regular basis in a state government. And temporary legislative powers. Where is the need for this extraordinary power? It is not contemplated. And then we are told the situation was not okay for elections to be held. That means that situation must only be attributed to the governor and the president. Because until then, the reason was that no political party is coming forth. So this, I'll finish. So this is malice and this power under Article 356, which is really subject, legislative acts there are subject to a post-appraisal by the state legislature. This power is ironically used to destroy all possibility of a legislature. So the people of Jammu and Kashmir don't have a legislature when the act is contemplated of abrogating Article 370, and it is ensured that they do not have any future legislature either. And my friends want your lordships to believe that this is an expression of the will of the people of Jammu and Kashmir. My lords, this is, a self-proclaimed agent through a series of proxies, strangling the principle and telling your lordship this is not murder but suicide. This is really that. And this CO272 is not only legally untenable because of what I said about Article 371 and the sui generis power. Only one page I want your lordships to see. There is this public functionary, volume 13, page 435.
Of the documents?
Just 1 second.
Here is a governor who gives video interviews. I'm aware that strictly a newspaper report is not evidence. It is not evidence in the sense that you cannot base a criminal conviction on it. But when a public functionary, former
What is
public,
this? What is this page?
this is a interview given, a video interview given by the governor who had dissolved the assembly, not the person who imposed governor's rule. And also, it's supposed to have given concurrence for CO270.
Page you are referring to.
He's still lingering on the.
13 pages.
This is an interview he gave to Wire.
Why I am interrupting?
And then
It's part of the compilation.
No, this is an implement filed in 22, never listed, for the first time being listed. Therefore, I am asking what?
Sorry?
Yes, which part do you want us to
I just
see?
want to read from the middle. So, Karan Thapar, so really you had no idea. He had no idea on the night of August 4 what was coming. And he has given concurrence like this. Satyapal Malik, absolutely nothing. I did not know anything. I was merely called by the Home Minister one day prior saying, Satyapal, I'm sending a letter tomorrow morning. Please get it passed by a committee for 11 tomorrow and send it to me. The whole world is aware of this. We cannot sit in an ivory tower and behave it never happened.
Post facto statement.
Post facto statements. Only at that level your lordship may consider it as post facto statement. Obviously, before that, he didn't even know, he could not have issued a statement. So this is people's will. Only two other points. This, your lordship will have to see Article 370, CO 272. It is true that in 1954, just 2 points and I'll finish. CO in 1954, when the Constituent Assembly was functioning and also doubling as a legislative assembly, for a brief while there was a CO saying references to the legislative assembly in the Constitution would be read as including a reference to the Constituent Assembly of Jammu and Kashmir. That was a situation where this made sense because there was a corresponding body which was functioning as a legislative assembly. But
This was in 1954, Ms. Nitya, this was in 1954, you said?
Yes.
She said for a brief period in 1954, when the Legislative Assembly.
Yes, there was a CO, which said, page 18. I'll read it.
Volume?
Documents volume 3, page 8.
Sorry, tell me again.
Documents volume 3, page, PDF page 18.
Oh, the CO 54.
CO 50.
CO 48 in 1950.
Sorry, CO 48 in 1950.
Let's just see that for a second.
So that said, my friends are relying on it, saying it was done then and we can do it now.
Let's to appreciate your submissions.
References,
In page.
1 second.
References to.
What is the page?
references,
What is the page number?
page number, internal page 18,
No, this is PDF page 8.
PDF page 8.
PDF page
18.
18.
1.
Oh, 18.
This was with reference to Article 367.
Yes. It was done under Article 367. So they're saying it's been done before and we can do it again. And I'll tell you lots of why that's completely fallacious.
Which clause is that?
Subclause 4D. References to the legislature or legislative assembly of the said state shall be construed as including references to the constituent assembly of the said state.
Just 1 second.
Was this withdrawn later on? No.
Yes, it was temporary and then it was changed. Once the constituent assembly stopped, then it was just legislative assembly.
No. Was there a CO issued?
Yes, the CO issued. CO 1958 removed.
The 1958 would be post Constituent Assembly.
Yes. There was no constituent assembly at that time. So,
Till the Constituent Assembly was there,
Huh.
this concept
Correct.
of 4D was available.
Yes.
That's it. Removal is page is at page 26, your lordship may note that.
What's the CO number?
56 in 1958.
I'm saying that makes sense because there was a constituent assembly functioning which doubled as a legislative assembly. What they have done now, my point is
I'm sorry, just what is the page number of CO number 56?
28, 26.
26.
26.
At 26.
This would be clause 7C, is it? In para 14 relating to part 19, C in clause C,
Omitted.
subclause D shall be omitted. Yes.
But what they've done by way of CO 272, aside from the argument that they could not have done it because there was no power under 371 with the center or with the governor, the absurdity, you see, it is as an exercise under Article 367, it leads to a semantic absurdity. Now, I'll tell you, Your Lordship, why. Your Lordship will just take a look at Article 370. I know Your Lordships have read it many, many times. I just want to show. Now, clause 3. It says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. And clause 2 refers to a Constituent Assembly for the purpose of framing the constitution of the state. Now we're making an argument on pure elementary logic. There is a reference to a Constituent Assembly as referred to in clause 2. Clause 2 remains on the book for reference. And it refers to a Constituent Assembly for the purpose of framing a constitution of the state. So there is a relationship of identity between what the Constituent Assembly in clause 3 and the Constituent Assembly in clause 2. A is A. And so long as these two remain on the book, you cannot now bring by way of an interpretation that A in 3 is not A. Because what CO 272 says in clause 3 alone, even what is referred to in clause 2 becomes something else, non-A. So long as this is there for reference, you can't include clause 2 and say it means something else. It's a logical absurdity. It's a semantic absurdity. It cannot, A is either A. A cannot be A and not A at the same time, but that's what they're trying to do.
All right, at this point we've got
Yes.
this.
Otherwise, the only way this exercise would have been valid is if they had, in fact, what they've attempted to do is they've removed all these words and substituted legislative assembly for it. In actual effect, that's what they've intended to do, which is an amendment. It cannot be an interpretation. And aside from that, even otherwise, A equals not A, Constituent Assembly is not Constituent Assembly. Governor who should act on the advice of Council of Ministers equals governor who is bereft of a Council of Ministers. The entire exercise, my lords, is full of Carroll and Lewis Carroll parallels. The whole thing is an exercise in absurdity.
All right, thank you.
And one last, and I have referred to Humpty Dumpty, I don't want to read it again. Changing meanings after the event, and that is it. And one last thing I want to tell your lordship, that this argument, even if Jammu and Kashmir flows with milk and honey, the argument that in order to secure people their constitutional rights and development, we have to destroy their entity, we have to destroy their statehood. That is the argument taken, and that cannot be countenanced regardless of anything. And one other, which is not a legal submission, and I'm not referring to facts, I'm winding up with this. In October 2019, with a friend, I visited the valley. And I was able to do it because I'm used to traveling unobtrusively, not because people were not stopped. The one name that resonates in the valley with faith is that of Mahatma Gandhi. They remember him as a man who lived and died for his word. Somewhere, that legacy must be kept in mind while deciding this time. That's all.
Thank you, Mr. Dr. Guruswamy. You have a formulation, Dr. Guruswamy? Do you have a formulation on paper, what you're going to be submitting?
I'm sorry, my
Do
lord.
you have a formulation on what you're going to be submitting?
Yes, my lords, and we've
Let's have a look at it.
we've submitted the note, my lords. I think it's page 4 to 5 of your compilation, volume 5. Page 4 to 5, volume 5.
Okay.
It's a 2-page note. My lords have it?
Yes.
My lord Justice Suryakant?
Yes. Peaceful.
Yes. My lords, yesterday, my lord the Chief Justice had posed a question to Mr. Dwivedi that can you look to the statement of a drafter, a member of the Constituent Assembly, and accord it as being enforceable on the will of the people. And it was a very important question. Volume 5, which
Yes.
only has the 1-pager or 2 pages that your lordship had asked for yesterday. So it should be
Yes.
14, 20 pages between all of us, my lords. Not just me, my lord Justice Khanna, between all of
Yes.
us. I saw that look of shock and horror on Justice Khanna's face.
Yes.
Be my effort neither to shock nor horrify, my lords. So this was the question posed by my Lord the Chief Justice yesterday. And it's a particularly important question because one, and I'll just formulate the proposition, because one, in this case, you have not one but 2 constituent bodies. So in many ways, it is unique to India's constitutional founding because it is the only state with its own distinctive constituent assembly. 2, it forces upon us this seminal constitutional question. Can the Constitution of India be altered in ways opposed to her founder's constitutional intention? And I'm not saying a drafter's opinion. I'm not saying a debate within the Constituent Assembly. I am saying, can it be altered in ways opposed to her founder's constitutional intention? When we think of this country's founding at a time of partition, from 46 to 49, our Constituent Assembly is drafting our constitution. At the same time, we know what is happening in Jammu and Kashmir. Ms. Ramakrishnan allude to that. The country's first Prime Minister giving his speech in Hindi said, we are a nation whose land is strewn with blood. Khoon se ranga hua hai ye zameen. That is our constitutional founding. So my first proposition is this. There are certain seminal founding moments for any constitution, but more specifically Indian constitutionalism. Why are those seminal founding moments important, crucial, significant while interpreting the constitutions as your lordships will? It is because my lords have walked the path of transformative and expansive constitutional interpretation. And your jurisprudential moorings, with great respect, derive their legitimacy, their integrity, and their intellectual rigor from these founding moments, from our drafters' constitutional intention. If my lords had chosen, since the 1970s, a different path of minimalist interpretation, of limited review, then we would not have to worry about constitutional founding moments. But your lordships have embarked on this methodology of expansive and transformative constitutionalism. And thank heavens for that, because that goes back to the needs of our difficult founding. The creation of this country, 2 constituent assemblies, and also the unique brand of federalism that was envisaged by our founders for the state of Jammu and Kashmir integrated with the Union of India. And it's not just Article 1 and Article 370, which is part of that constitutional intention. It is much more than that. It is the specific provisions, and I'll take you to them very briefly. My lords have read it. I'll just refer to them. It is the specific provisions of the Constitution of Jammu and Kashmir, sections 4 and 5. It is the specific provisions of territorial integrity of the state of Jammu and Kashmir that our founders promised and the Jammu and Kashmir Constitution recognized in its constitutional text. Such territorial integrity was not promised to any other state. This is all part of the founding constitutional intention. Now, in the 1960s, on an aside, my lord, when Thurgood Marshall was asked, why is it so important to have Brown versus Board desegregate America? He responded saying that it is not about their humanity. It is about our humanity. So today I present to my lords a different version of that. It is not simply about that constituent assembly. It is about the promises of our constitution assembly. It is about that legacy of interpretation that my lords started 4 decades ago. That is what this founding movement is about. That is what this model of federalism is about. That is what the intricacies of this model of federalism that embraced this version of what Ms. Ramakrishnan called shared sovereignty. That is part of India's federalist structure. Now, please see, my lords. May I take my lords to section 4 of the Constitution of Jammu and Kashmir, 1957. And the second proposition is this, and it's in the note. The abrogation of Article 370 has vitiated the unique internal sovereignty guaranteed by both constituent assemblies of Jammu and Kashmir and India. And this is in the middle of the note, my lords. So part 2 of the Constitution of Jammu and Kashmir categorically retains internal sovereignty with the state, along with residuary powers to the state government. This is unique to Jammu and Kashmir and distinct from the rest of India, where residuary powers under Article 248 is vested with the Union Parliament. And to this, my lords have sections 4 and 5, but 4 simply says this. It provides that the territory as under 15th August 1947, under the sovereignty of the ruler, that territory is comprised of the territorial integrity of the state. And that territorial integrity of the state is guaranteed to be protected. And section 5 simply says this. It provides that the legislative assembly of the state and all executive and legislative powers, so the legislative assembly of the state is vested with the residuary powers. Now, this brand of the vesting of the residuary powers, the legislative residuary powers with the state assembly, is unique to the state. So whether we want to display that in a conventional setting, a conventional telling that only external sovereignty has been surrendered by the state in terms of Article 371. And that's a sub-proposition, and internal sovereignty is retained by the state, or whether we want to say that this is shared sovereignty between the state and the union, between the two constituent assemblies. Either which way, and my lords have heard arguments speaking to both those ideas, but either which way, this brand of sovereignty is unique to the state of Jammu and Kashmir, and it is especially important in appreciating the unique federalism that is ascribed to the state in the federalism that speaks to India. My lords, on this note, I won't take you to the speeches, but on this note, we've just made 2-3 references, my lords. Speech of Kotwal Chunnilal during the Constituent Assembly debates of Jammu and Kashmir. And your lordship will just mark that. And that is in the volume compilations. I'll just read a line from that. And he makes only 2 points, that the territories as on 15th August 1947, which were under the sovereignty of the ruler of the state, that is what the state will comprise. And within that, the state will have a legislative assembly and a legislative council. So dual houses and territory ascribed and guaranteed and promised. This is part of the founding. And all of that is marked, my lords, so I won't trouble my lords with it. Now the fourth proposition, my lords. The abrogation of Article 370 and the subsequent Jammu and Kashmir Reorganization Act 2019 by abolishing the bicameral legislature of the state has further violated the unique legislative autonomy secured by the state of Jammu and Kashmir. And this is just on top of page 2, my lords. Now, for this, my lords, I'll just take your lordships to sections 46, 47, and 50 of Constitution of the state of Jammu and Kashmir. And my lords, that's in volume 2.
We have it here actually in your note itself. It's the article
Yes.
section 46.
It's in volume 2, my lords, of the documents.
46 is at
Section
page 5.
46, my lords, pertains to the legislature for the state. There shall be legislatures for the state.
It's a bicameral legislature,
Yes.
both the legislative assembly
bicameral.
as well as the council.
Yes,
It is extracted in your
At
page
page
2
5.
note, as the Chief Justice said.
yes, my lords. But my lords, what is important and interesting about this legislative model is that section 47 and section 50 provide for the composition of the legislative assemblies, the assembly and the council. Now, the reason why I'm belaboring this is because the composition speaks to a unique, my Lord Justice Suryakant has that.
Yes.
The composition speaks to a unique regional model of governance. And that unique regional model of governance was only ascribed to the state of Jammu and Kashmir. So 46, 47, and 50. 47 provides for the composition of the Legislative Assembly, and 50 provides for the composition of the Legislative Council.
Essentially, para 7 says.
Yes, Manoj. Yes, Manoj. Now, section 50 of the Constitution of Jammu and Kashmir has unique requirements of this composition. And this shows a thoughtful regional understanding of the state. The Legislative Council is intended not only to have members from districts, but municipal councils, town area committees, panchayats, so on and so forth. Now, this is a very different understanding from Article 171 of the Constitution of India, which provides for legislative councils of a different kind. I just read, my lords, Article 171. Well, it's Article 171 speaks to the composition of legislative councils. Total number of members, my lords, of each council shall not exceed. Now, subclauses 3 and 4. These are only specialist qualifications. The idea of 171 is not to provide for representation by region, but only to have specialists or memberships of members from specialist institutions.
9A of the Constitution.
Self-governance now in the Constitution has come in a different fashion. It was not prevalent then. So possibly the thought process at that time while creating the bicameral houses was to provide such representations from the ground root level. But the Indian Constitution has also changed over by inclusion of that.
My lords, the reason why I'm showing these distinctions, and my lord is very correct, but the reason why I'm showing this is that there was a method, an intention on how to keep, one, how to recognize the state, two, how to bring the diversity within the state together.
Get a representative character from a base level, sir.
Yes, and diversity of regional representation, the only legislative council which had reservation on religious grounds, Sikhs, had seats. Very unique. So there was an understanding of the people who knew the area best, that there would be a certain regional representation to hold together Jammu, Kashmir and Ladakh. There is no other legislative council which is thinking through regions, which is thinking through minority representation in this form. So when you take that area and divide it up and chop it up into 2 union territories, you take away all representation from Ladakh.
You got the point. Thank you. Anything else, Dr. Guru?
Yes, my lords. Just two brief points. So, my lords, following the abrogation of 370 then and subsequent state reorganization, the Legislative Assembly, 111 members, and the Legislative Council, 36 members, were dissolved. And then you had the state conversion into 2 union territories. Now, of course, Article 169 of the Constitution of India provides for a mechanism of the abolition of legislative councils. I'm saying this, my lords, because it is not as if only 370 has been miraculously removed and ejected in ways violative of constitutional intent. It is that everything that has happened has been contra the Constitution of India, including, for instance, the dissolution of this Legislative Council, which was envisaged by our framers. The legislative councils are meant to be dissolved in a certain manner, but certainly not in this fashion. And that constitutional intention of a recognition of identity, of a recognition of representative democracy, of a recognition of unique federalism, extends to all of this. So you are not just running roughshod over 370, you are running roughshod over the small, how you dissolve a legislative council, and the big, how you don't hold elections for the last 4 years.
What is the next point? What the second point?
Yes, Parvez. Now, my lords, a small point is that prior to the impugned actions, Ladakh had 4 MLAs and 2 MLCs. It also
Just permit.
my lords.
You said Ladakh had 4 MLAs
Ladakh had 4 MLAs, my lords,
and
and 2 MLCs. 4 MLAs after the delimitation in 1995, and 2 MLCs pursuant to Section 50, my lords, of the Constitution of Jammu and Kashmir. Also, my lords,
representation
Yes.
goes away. I mean, the legislature itself ceases to exist.
Yes, my lords. And my lords, also the Ladakh Autonomous Hills Development Council Act 1995 provided for this Hills Development Council, which provided for decentralized autonomous bodies for governance.
And that has been rendered null.
Yes, my lords. Null and void.
All right, thank you.
This is also. Now, my lords, just two other short
Yeah,
points, and
yeah.
I'll make it very brief. One, my lords, so I should tell my lords, I appear in two matters, so that my lords has that. Writ petition, my lords, 1048 of 2019.
Sheet का है वो.
Writ petition 1048 of 2019.
And you had it only that you are for as an intervener,
No,
Awami
my
National Congress.
appear in two matters. This is writ petition 1048 of 2019
And
and intervention number 138432 of
Is that-
2023.
138.
138432, my lords. 2023, that's the Awami National
I think
Conference.
maybe the nodal council will have to just update our sheet because
Yes, ma'am.
just maybe you can update the sheet anyway, anytime today in the afternoon or evening. Just give it to the court master
Now,
because we,
writ petition is Shakir Shabir and the IA is the Awami
Okay.
National Conference. Now, the reason why I'm mentioning this also, my lords, and I'm cognizant, my lords,
Yes.
of the large clock at the back. My lords, we're tuned to your lordship looking to it. But my lords, it's this, that in the writ petition 1048 of 2019, there is also a separate intervention.
all right.
And that IA actually speaks to delimitation. And that is
Yesterday
I-
only, we said that that issue stands concluded by the judgment of my Lord Justice.
Yes. Now, my lords, respectfully, the judgment of your lordships, Justice O categorically states that the abrogation, the State Reorganization Act is not being challenged in this judgment. My Lord Justice Call knows that. My Lord Justice Call knows that. Therefore, my lords, and Justice Oak in that case also specifically says that counsel should have raised it initially, or it should have been pled in the petition. He says that in his judgment. And because it is not pleaded, we are not assessing delimitation in context of that. That is abrogation and reorganization.
We assessed the limitation, but we did not go into any other issue.
Yes.
Those issues
My
were
lords,
discussed in
may I just show you those?
How does unless there's a reference made or something made, how does that issue crop up here?
My lords, because your lordships are seized of everything that falls out of abrogation and reorganization, including delimitation.
But that part is concluded by the judgment. I mean, there's no reference to this bench on that issue.
But my lordships, at that time, justices call.
Somebody should have come there then. We have heard other people there, whoever wanted to on delimitation. If this person was so keen, and that also, he has moved an application of intervention in this 1028 of 2019. He is not a petitioner. According to you, is through
No, my lords, the same petitioner. This writ petitioner,
he filed a separate application.
yes, in his own writ petition, has filed an additional application vis-a-vis delimitation because it occurs subsequently.
This can't be in the form of an application and a
In
petition.
a matter of this nature, it becomes too complex to get into this. You have to confine to what is there before us.
My lords, I follow and I bow down, but I will only say this, my lords, and your lordships may just, I will only say this, that at present, not only have this state been turned into two union territories, the delimitation exercise, which breaks down individual constituencies, which goes against that regional autonomous model of federalism promised in the constitution of Jammu and Kashmir, is now rendered not.
That point you have made.
And therefore, I went through all those points to show that this is a unique model.
That's fine. That's
Now, if
That
you,
point you have made, though.
yes, now if you've chopped up those constituencies, and that is what has happened, my lords, it's a chopping up of constituencies.
That will happen. Delimitation exercise always envisages inherently a change of constituencies.
My lords,
Otherwise, why have a delimitation exercise?
But my lords, the respectful submission is that the delimitation exercise must either conform to the constitution's requirements.
Okay, that we've adjudicated.
Yeah,
We'll not-
and given that your lordships are seized of abrogation and the Reorganization Act.
That's fine. That's
That's
fine.
all right. That point you have made, that, this eats into the regional autonomous model of federalism. That point you have taken.
Very well.
Thank you, Dr.
So, my
Gulbakshi.
lords, just that, and then I'll end with this,
Now,
my lords.
Manish Tiwari will call upon. Yes.
My lords, I'll just end with this one
It's almost
point.
30 minutes now.
30 minutes, my lords, it can't be. It's felt like 2 minutes. It's the best 2 minutes.
What is before us?
All right. Yes.
No.
Last was the point. Yes.
I'll just end with this, that part of this is that we made promises. We, the people, through our drafters, made promises. It is surely an axiom of decency, constitutional integrity to keep our promises.
Thank you, Dr. Gulbakshi. Yes. Now, Mr. Manish Tiwari. Yes, Mr. Tiwari.
May it please your lordships, our intervention application number is 160049 of 2019. In writ petition number 1013 of 2019. In the paper books volume, the intervention application is at PDF page number 409 to 420. And our written submissions are in the written submission synopsis volume at PDF page number 610 to 644.
Volume?
This is the PDF volume on submissions, synopsis, and formulations, Your Lordship.
You represent whom, Mrs. Tiwari?
I represent Padi Richu, a former minister in the Arunachal government. And may I commence by answering what the Lord Chief Justice had referred to yesterday when we were going through the scheduling, that the 6 subparts of Article 371 are not before your lordships in this matter, and that is absolutely correct. However, the underlying principle of autonomy in Article 370 and 371 is more or less the same. And so therefore, what your lordships will hold in this matter, either way, will have implications on Article 371. And that is what I am here to respectfully point out. Your lordships, the Constitution of India, in addition to being a politico-legal compact, also served as a national security instrumentality in terms of unifying the periphery of India to the hinterland, because national security is not merely the use of the hard power of the state. Your lordships, when the British were ruling India, they actually managed the periphery through a process of treaties. And since there is a paucity of time, I will not lead your lordships through the various treaties in the northwest and the northeast of India. But independent India decided to manage its periphery, its realm, through constitutional guarantees. And the reason is because they were managing an empire and we were building a republic. And that's how Article 370, which applies to Jammu and Kashmir, which is a periphery state, Article 371, the 6 subparts which apply to the Northeast, and the 6th schedule of the Constitution, which applies to Assam, Tripura, and Meghalaya, becomes relevant and germane in this matter. And may I very respectfully point out, your lordships, that even a slight apprehension in the periphery of India can have serious implications, and your lordships are currently dealing with one such situation in Manipur, and I will not belabor that point further. Before I come to the Northeast, Your Lordship, I just wanted to
I'm
point.
sorry for the interruption. Kindly give me a minute indulgence. And I have instructions to say this. But we have to be very, very responsible in assisting your lordships, and we must understand the difference between temporary provision, which is Article 370, and special provisions with regard to other states, including Northeast. The central government has no intention to touch any part which gives special provisions to Northeast and other regions. This submission would have a very potential mischief, and therefore, Lord, I am interrupting and making it clear. Let us confine to a temporary provision for Jammu and Kashmir. Rest are special provisions, not temporary provisions. So there is no apprehension, and let us not try to create that apprehension. I am not putting that apprehension at rest on behalf of the central government.
Your Lordship, may I very respectfully point out, I was not referring to the current central government. I was referring to the principle at
So
stake.
why should we deal with anything in anticipation or in apprehension? We are dealing with a specific provision, namely Article 370, which was applicable or is applicable according to you to the Jammu and Kashmir. We don't have to really expand this ambit on what the impact of our interpretation would have on other provisions of the Constitution.
Your Lordship, may I respectfully point out.
There is also another thing in what he says. This is a special provision, 370. 370 is stated to be a temporary provision. Of course, the councils have argued it is not temporary, that it was temporary in the context of a assembly. And all those aspects are the interpretation of 370. I think touching 371 is something which we should get into in these proceedings.
And particularly once, as a constitutional principle, the Solicitor General is informing us that the government has no such intent. Why should we apprehend that, this is what the government is about to do in other parts of the country?
Your
That's
Lordship,
not
may
before us, and I don't think we should really enter into that terrain at all.
Your Lordship, may I respectfully point out, you're absolutely correct, with regard to the
Broader impact of, say, the abrogation of a state into a union territory, what could be the fallout in other parts of the country? Certainly that point has been made, that's present to our mind. But let's not now place specific focus on Northeast, that you will probably do this in the Northeast. I think the apprehension is allayed by the statement which has been made on behalf of the government. And beyond what was argued by the petitioners, namely that if you permit, and that is independent of Jammu and Kashmir, if you permit the abrogation of a state and its constitution into a union territory, why would it be confined only to Jammu and Kashmir? That point has been made. We have made a note of that. We will be hearing on the response to them.
Tiwari, just one. I think as far as the other parts of Northeast is concerned, because your written submission specifically talk about that, in view of the statement made, I don't think we are required to go into all that. One. Number two, as far as Article 3 and 4, whatever is there, if you have any submissions to make, just confine to those articles, the horse Northeast, that's possible. But otherwise, we are dealing with only 370 and Article 3 and 4.
Your Lordship, I am extremely cognizant of what has fallen from your Lordships. And I will try and confine my arguments to the constitutional interpretation, primarily because you were absolutely correct that while Article 370 has a subheading as a temporary or transitional provision, 371 and the rest of the provisions are also have a subheading as a special provision. So therefore, I am not trying to equate temporary, which has been argued as permanent, with special provisions, but the underlying principle of autonomy, which runs through 370 and 371, is the same. And that's the limited argument that I want to make. So, Your Lordship, before I go on to the arguments with regard to the Article 3 and 4, may I very respectfully point out that
Mr. Tiwari, there are even certain special provisions with respect to state of Maharashtra also. State of Maharashtra and Gujarat. Why should what we are interpreting is only 370?
Your Lordship is absolutely correct, and that's why.
See, the interventionist. basis his intervention only on one principle. And that is 371A. Once we are not touching that, what does the interventionist have to say in this matter?
And Mr. Tiwari, ultimately, you have nothing to say on Article 370. So then why should we hear
Your
you on
Lordship, may I
371?
just make a submission with regard to 370, and then, I will try and make a submission as your
But
Lord
there's
Justice
nothing that
Khanna
you have
said with
formulated
regard
in
to
your
Article
submissions
3
on
and 4.
370. You have not formulated anything in your submissions on 370.
Your Lordship, there is a submission on 370 in our written submissions.
Let
In
us read
fact,
that and then we can close on that.
619 to 623 of our written submissions, Your Lordship.
With respect to different area, they are different. There is no conflict. 378, when
Your Lordship,
A is
may I
different,
just be
378 is
completely? Your Lordship, may I be? Your Lordship, Your Lordship, may I make a submission with regard to 370, and then I'll go on to Article 3 and 4, which we have formulated in
Mr. Tiwari, what we'll do is we'll close your IA by taking the statement of the Solicitor General on the record, and we'll just close the IA right now so that there's no ambiguity left in on the adjudication on the IA or in the position of the union government on any of the states in the Northeast.
Well, your Lordship, if your Lordships on the statement which has been given by the union would like to close the IA, I have absolutely no objection to it. But may I just make one submission with regard to 370 with your indulgence? And that.
Tiwari, that's not what the applicant has come for. Applicant has come with some other basis. Whatever apprehensions may be in the mind, which was not subject matter here, is also allayed by the statement. Why should we, in these 370 proceedings, take up, you yourself says it's a very sensitive area. Why should we take up?
We'll just say that the applicant, urging their submissions through Mr. Manish Tiwari, Learned Counsel, has urged that apart from the provisions which are contained in Part 21 of the Constitution pertaining to the state of Jammu and Kashmir, there are special provisions in the Constitution governing the Northeast in
other
the
states
same
also.
part. His submission governing the Northeast in the same part. Full stop. Hence, it has been submitted that the interpretation which would be placed by this court on Article 370 may possibly impact upon the other provisions. Full stop. The Solicitor General has submitted on the specific instructions of the union government that the union government has absolutely no intent to touch or affect any of the special provisions applicable to the Northeast and to any other part of India. Full stop. Next. The reference to the Constitution bench is confined to the provisions of Article 370 of the Constitution. Full stop. There is no commonality of interest between the issues which are sought to be addressed by the intervener and the issues which have been raised in the reference to this Constitution bench. Full stop. In any event, the statement which has been made on behalf of the union government would allay any apprehension in that regard. Full stop. We therefore close the IA, which shall stand disposed of.
Obliged. That's in addition to the
well-settled principle that in constitutional adjudication, court will not frame a question that doesn't directly arise for adjudication. We will not stray into all those areas where court need not go into.
We'll just say, thank you. Ms. Varisha Parasat. Yes, Ms.
Very cognizant of the time, and I'll be very brief. My lords have heard very lengthy arguments, so I want to start by a quote by the Soviet premier at the time, Nikita Khrushchev. And what he said was very interesting. He said, "You Indians are a remarkable people. How did you manage to liquidate the princely states without liquidating the princess?" So, my lords, I want to start by saying that in fact it was the constitution writing was a remarkable exercise, and the coming together of the Indian Union and the Indian Federation was a remarkable exercise. And it's in that context, and even the Soviet premier of the time, because it was not common practice. These nations were being born. And so, my lords, I started with that. To come to my first point, I have 3 quick points, and I'll try and make them very quickly. The first is about the concept of federalism as it operates in the context of India. And to that extent, my lords, I want to say that yes, at one level, Jammu and Kashmir is unique, but at the other level, it is also part of a federal union as federations are understood. And I want to take the example of the United States, because it's the first democratic country, federal country that comes to mind. And my lords, in fact, the US National Constitution is a very thin text. My lord knows that. It only has 7 articles supplemented by a total of 27 amendments. And it is importantly Article 1, Section 8 of the US Constitution that enumerates the specific powers taken over by the Congress and the federal level of the government, leaving all other spheres of autonomy to the states by default. This is the 10th Amendment, which expressly defines this data. So, my lords, my point is that federations, as we understand, can have a variety of permutations and combinations. There is no one kind of a typical state, even within federations, that can be envisaged. And my lords, my point then comes to Jammu and Kashmir, and how do we envisage states within the Indian Federal Union? My lords, there are various ways. One is we have a union territory. So, in a way, it's state minus. Then we have something, my lords have dealt with it extensively in the GNCTD case, that it is a UT, but with legislative powers, my lords. And so then you have something like Jammu and Kashmir, my lords, which is a state plus with its own constitution. And so a constituent assembly was formed and a constitution was given. So, my lords, we must see that there are various permutations and combinations, and it is unique, but also a normal part of federalism. And my lords, there is a very important concept within federalism. One is holding together, and the other, my lords, is coming together. So while and my main proposition is that while most of the Indian Union represents what has been called a holding together type of federation, where a multicultural polity with strong unitary features constitutionally splits autonomy between the Union and its regions to hold those regions together. However, Jammu and Kashmir represents much more a coming together federation, my lords, where previously sovereign polities pool their sovereignties and resources to come together and form a more secure and long-standing union. So it is within that we are envisaging the federalism that is envisaged for JNK. My lords, I have said, I've said various things in my note, it supplements it, but I'll quickly then come to my second point. And my second point is about the fact that when we look at Article 368, I'm saying let's forget Article 370 for a little while and the constitutional amending provision that 373 provides. Let's just look at Article 368, which is the constitutional amending power. Now, by their very nature, a constitutional amending power is far stricter than the normal legislative powers that even the parliament has. My lord, so therefore there are many checks and balances that Article 368 envisages. That is not envisaged in the general legislative powers that are exercised either by state legislatures or by the parliament. So my lords, therefore, when we are reading 370, so what is my point? My point is that therefore, when we are reading 370, it must be a very strict interpretation of what can or cannot be done. And therefore, when we are reading 370, it cannot be that in a casual manner, we are substituting one authority with another, as has happened in the constitutional orders that have been promulgated. My lords, I then come to, in fact, my Lord Chief Justice's question while I'm answering this. And my lords have read this article, I don't know how many times, 370, but may I please urge you to read it once more with me. Please, my lords, if you can come to Article 370 once more, because my lords have asked a very important question from all of us on this side, and that is that how do we read 2 and 3 and the Constituent Assembly part in it? And there's a clear answer for that. My lords, if we read, sorry. My lords, I apologize. Just, yes, if my lords can read para 2 with me once more, there's a clear answer. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1, or in second proviso to subclause D of that clause be given before the Constituent Assembly, for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision as it may be taken thereon. My lords, I'm making a simple point that this was a transitional provision because of the fact that it uses the word before such assembly. It only provided a protection to place before the Constituent Assembly when a Constituent Assembly had not been formed. After that, the power that is vested in 2 was subsumed by 1. And therefore, it answers my lord's questions that are the subsequent presidential orders legal? Yes, they are, because they are not under exercise of power under 2, but under 1. And my concomitant point with that, my lords, is very respectfully. So our constituent, assembly makers, or our constitution makers were aware that at some point in time, the Constituent Assembly of J&K would have served its purpose and would no longer be there. And for that particular purpose, they had given that how can you make changes, and that was provided under 1, right, my lord? So therefore, they were equally aware that the Constituent Assembly would cease to be in power. Yeah. Yes, only before. My lord, I'm sorry if I'm moving very quickly, but I'm just cognizant of the time. My lord, so my essential point here is that the constitution makers were aware of the fact that the Constituent Assembly would finish its function and then no longer exist. And therefore, for making any changes, they had provided for the via 1. But for the abrogation, they only left it to the Constituent Assembly. My lords, there is no other way to reconcile the two. My lords, otherwise, how do we say that the presidential orders, and that's a question that has been falling from my lordships, I have seen very much from day 1. And the only way to look at it is that clause 2 was a transitional provision, was only provided for, and my lords, there is logic in it. Because of the fact that before the Constituent Assembly was formed, the government would have needed concurrence. Because it was transitional, we did not know how exactly they represented, whether they represented the will of the people, etc. or not. And then after that, there was an assumption that the government of the day would be representing the will of the people. And so, at least with respect to certain decisions, at least with respect to making certain other parts of the Constitution applicable to the state. However, equally, my lords, if we take that interpretation, then we'll have to set in time the Constituent Assembly and its power and the recommendation being necessary for the abrogation. My lords, because then it will reconcile. And my lords, just one very quick last point is the question, my lords, that even if we left everything aside, my lords, what happened on 5th and 6th of August 2009? And my lords are a constitutional court. My lords, 3 former chief ministers were in detention. And these are all facts, my lords. 3 former chief ministers, most of your legislative assembly. My lords, the will of the people is exercised by the Legislative Assembly, were in some form of detention or the other, either under the Public Safety Act or, my lords, under 107, 105. It's laughable. In Delhi, if, entire polity and all of the politicians who have actually supported you, who've been legislative members, are put in this manner. And therefore, I come to my last but very important argument that this is malice in law. Because what this demonstrates, my lords, and how do we determine malice in law? By the actions surrounding the abrogation itself. And my lords, I'll just read very quickly because I don't want to burden my lords with reading anything at this stage. But malice in law is a very well settled principle. I'll just read it. And it has been held by this honorable court as follows. This court has consistently held that the state is under an obligation to act fairly without ill will or malice in fact or in law. Where malice is attributed to the state, and my lords, we are doing that, it can never be a case of personal ill will or spite on the part of the state. Legal malice or malice in law means something done without lawful excuse. It is a deliberate act in disregard to the rights of
read your
others.
submission below the quotation because
Yes,
that will help
yes,
us.
Lords, it's there.
The
And-
abrogation of Article 317
Yes, yes,
was effected secretly. You can read that, those 2 sentences there.
yes. Yes, my lords. The abrogation of Article 370 was effected secretly, unilaterally, and coercively. Not only was the democratic process disregarded, but also the people and their leaders were kept in the dark, prevented from communicating with others, my lords, and even detained till the Union of India could issue them a fait accompli. In times when pre-legislative public consultations, my lords, and post-legislative social audits, my lords, we know that even before, there's talk of whatever law, there are public consultations and deliberations. But here, my lords, what has happened is that the will of the people has been trampled upon. And there can be no other reading in this regards, my lords.
Thank you so much, Ms. Faseth, I think.
Whom do you represent?
My lords, I am in...
No, who is he?
My lords, he's an RTI activist. He's a very well-known and respected RTI activist. I'm so grateful.
Ms. Phil.
Your Lordship,
Yes.
my Lordship, I'm a little bit nervous because due to the time constraint, I will try to avoid repetition and try to assist my Lordships. Lordships, it's imperative sine qua non to slightly touch the provisions of 370, Concurrence 356 and Article 3, and federalism and democracy. Very briefly, my lordships, and the circumstances under
Can we
which,
just run through your note?
very briefly, within
Let's
1 minute.
look at your note. Let's look at your note. So it'll just bring clarity on what you want
Yes,
to
Your
argue.
Lordship. Your Lordships, and the circumstances under which instrument of accession was signed, and the letter to the Maharaja by the Lord Mountbatten, wherein he says that no sooner the normalcy returns, the will of the people will be ascertained. And I believe, Lordships, the will of the people was expressed by the Constituent Assembly, but by the J&K Constituent Assembly, and they framed the constitution and defined the constitutional relationship between Union of India and State of J&K. My Lordships, the Constituent Assembly of J&K provides in Article 370, my Lordships, in 370 is a self-contained provision which prescribes very candidly that consultation with regard to the instrument of accession, the subjects mentioned, and by that reference, my Lordships, the instrument of accession is part of the 370 because whenever we take recourse to the subjects, we have to take recourse to the instrument of accession. My Lordships, I have in my submitted the document which I obtained under RTI with regard to supplementary instrument of accession signed by the other states. J&K is the only state which didn't sign the supplementary accession, only state. Your Lordship, 370 is the constitutional recognition to the instrument of accession. My Lordship, but the manner in which the concurrence, which is very candid, clear, my Lordships, express provision of the law, that concurrence means on the aid and advice of the councils of the ministers. My Lordship, the J&K Constituent Assembly in 1957 conveyed that the 370 will remain in the same form. They didn't recommend its abrogation. In fact, my Lordships, they recommended that it will continue as they pass the resolution. And my Lordships, the Constituent Assembly of the J&K temporary provision was only because it was left to the discretion of the J&K Constituent Assembly to take the final decision. Now, Lordships, the concurrence by the governor is not permissible under law because, my Lordships, concurrence affects the autonomy of the state. It's because of that reason the concurrence is to be given by the duly elected government. It cannot be the governor under the Articles 93 or 356 of the Constitution. My Lordships, the Article 3 of the Constitution says, view of the state. What happened in Jharkhand? 2 years, 3 years debate. Telangana when was formed? And with regard to J&K, 356 invoked, the relevant provisions suspended, which is unknown to law. And with regard to J&K, there was consent. My Lordship, I was a full-fledged state. I was having my own constitution, 1939, prior to the Indian Independence Act. And it's because of that reason, the other side of the Kashmir, which is with our neighboring country, they have right now, maybe on the papers, they have the Prime Minister, they have the President, they have the legislature. I'm functional democracy. I'm proud of it. I'm a nationalist. But Lordship, I take liberty to share with my Lordships. People make mockery of me. Is this democracy you're proud of? They have this full-fledged state. I was having within the constitution my prime minister, my Sadri Riyasat, my legislature. I'm reduced it to the UT, LG. Forget my Lordship about the prime minister. 65th amendment in 65, 6th amendment in JK Constitution, Sheikh Abdullah was in jail. The amendment was made and this nomenclature was changed. Lordship, I'm concluding. Very important, Lordship, with regard to the will of the people, Lordship. The will of the people is of paramount importance. Federalism, rule of law, democracy, Lordship, is the soul of constitution, basic structure, held by in the Keshavananda Bharati case. Lordship, it's not mere elections democracy. It's beyond, it's vast, functional democracy. My Lordship, will of the people is of paramount importance. I'm alive of the fact, Lordship, courts are not to get swayed away. I'm 1 minute only, Lordship. Yes. Courts are not to get swayed away by the emotions, but Lordships, here in this instant case, the will of the people That is the Constituent Assembly of the J&K. The sentiments, aspirations, the desire of the people is intrinsic to the will of the people. That is to be looked by lordships right now. Lordships, I am concluding, but this is very important, lordship. That is the report of state autonomy, which is the will of the people. This autonomy report is by, it's A290, volume 14, your lordship, document compilation. The government has set up, your lordship, it's very important.
What is the page? PDF?
Page A290, lordship.
Can somebody give us the...
Volume 14, lordship.
1 second, give us. All right. What is the point in there?
Point is, my lordship, the state government set up a committee to examine the question of restoration of autonomy, the state of Jammu and Kashmir, by government order number 196. Dr. Karan Singh is the head of the chairman of this committee. There are other members. Lordship, within 1 minute or so, I will conclude. This is the aim and object of this committee. However, other states exercise the choice. Yes.
519.
Page A2.
Yes.
How other Indian states exercise their choice, how they participated in constitution framing, and in what form did they adopt it, in not our concern. This shall be referred to whatever necessary in page to follow. But it's relevant to mention here that whereas other princely states signed the instrument of accession to India and subsequently the instrument of merger, the accession of J&K state was limited only to the areas of defense, external affairs, and communication. Uniquely, J&K state is the only one to have negotiated the terms of membership of the Union. Right till the Delhi Agreement, it did not accept any provision of the Constitution of India other than those agreed to the instrument of accession and retained its autonomy. Autonomy has remained since the days of accession, the heartbeat of the people of the state. State has lost all resemblance to autonomy. Its erosion is the primary cause of Kashmir discontent. Keeping this in view, Shri Narasimha Rao, the then Prime Minister of India, announced in 1995 that the Union government would be prepared to consider autonomy short of independence for Jammu and Kashmir. Mr. Devi Gowda, as Prime Minister, offered Jammu and Kashmir maximum autonomy. The assurance was incorporated in this common minimum program of the National Front government. This is very pertinent, my lordship. This is the autonomy resolution. Recommendations are there. This is by the state legislature. This is the will of the people. Lordships, Justice Sagir, a working group was constituted. One of important was headed by Justice Sagir. And the recommendation of that very committee was that the autonomy be restored to state of J&K. My lordship, J&K was having its own constitution. This is embodiment of my emotions, desire, and aspirations, the J&K constitution. My lordship provides the flag under section 144, which is made dysfunctional by the 273 CO, impugned COs. My lordship, very briefly, lordship, with regard to the which is very vital and very important.
The others who have to
only 1 minute, lordship. That is the Delhi Agreement.
That about 3 minutes ago, so I think we'll conclude.
1 minute, lordship. Only 1 minute.
Thank you very much, Mr. Bhatt. Now, Mr. Bhatt, Mr. Zahur Ahmed Bhatt.
I pay lordship, keeping in with the democracy, federalism, and the self-contained provision of 370. We pray that it's not sustainable, the impugned COs. So justice be done with the people of Jammu and Kashmir, lordship.
Thank you.
Thank you.
Obliged,
Mr. Bhatt.
Lordships, I teach Indian polity to the students in Jammu and Kashmir. And it's very embracing and very difficult for me, like people like me since 2019. When we teach this beautiful constitution and beautiful democracy, and when they will ask, are we really a democracy since post 19 August 2009, since August 19? And it's very difficult for us to answer. Basically, it was very unbelievable on 4th August 2019, when despite the assurance of Honorable Governor, then Governor, that their Article 370 will not be abrogated, in the midnight, curfews being imposed. All three chief ministers cabinet
Can you
minister.
formulate your point. Just formulate the point now, because we've heard all this, almost for the. Also, I'll tell you why there are other people. Mr. Shankar Narayan has been waiting here for the last 12 days of hearing. Oh, how many days? 11? We have to give him some time. So please give us your specific point so we can leave some 20 minutes at the end. Mr. Beg has to argue for 10 minutes.
Within 2 days, 5th and 6th August, special state of Jammu and Kashmir was downgraded into 2 union territories, Union Territory of Ladakh and Union Territory of Jammu and Kashmir. These impudent actions are completely in violation to constitutional morality of Constitution of India, right to democracy and consent of the people of Jammu, Kashmir and Ladakh, procedure established under the law, national interest of this country, cooperative federalism, supremacy of constitution, rule of law. On 5th August and 6th August, Jammu and Kashmir had the legislature, which had basically the legislature of Jammu and Kashmir comprises legislative assembly and legislative council.
That point was made just this morning by Dr. Guruswamy. He has made the point.
What I'm going to tell.
Yes. Don't repeat that, because that has already been made this morning. Just you are listening to it.
Yes.
Same point has been made.
In legislative council.
Get on with something new. Tell us something new. And by Ms. Ramakrishnan also has made the same point in the morning.
I'm submitting legislative council is having 36 members. And it was not dissolved on 5th and 6th August. It was dissolved in October 2019. So it was in operation. Legislative assembly was dissolved in May 2018. So because the state legislature comprises legislative council and legislative assembly. On 5th and 6th August, it was there. So if we respect the consent of the people, which is federal, this is basic structure of the constitution. So there could have been option to get any concurrence from, even a recommendation for this Reorganization Act from state legislature, which is mandatory. So part of state legislature was that. So when we see this was ignored. This was ignored and is not highlighted as on date. That legislative council, 36 members, they were also detained. Some of them were detained, some of them were not detained. It
is already told to us by so many people that is all 3 CMs, legislatures, they were all detained.
Few were detained, few were not detained, because we don't have absolute this information. It was whole the state was under the blockade. Now, Lordship, when we go to Jammu and Kashmir State Reorganization Act, where Proviso 3rd is suspended, so it was mandated for that. So it was there is on.
All right, thank you, Mr.
Very important submission. Proclamation dated December 2018. The president is knowing that this shows the intentions, because legislative, when we will get this Reorganization Act in the parliament, there it mandates state legislature. We are prior before 1 year. In proclamation, Proviso 3rd is being suspended. Coming to the Article 371, important point which I want to highlight here. One is consent of the people was not respected, which is the very beautiful and basic structure in our constitution. Article 370, basically, it was, as Goswami, this ma'am said, that it was the constitutional intention of Constituent Assembly of India and Constitutional Assembly of Jammu and Kashmir. They issued them some guarantee, and Constituent Assembly of Jammu and Kashmir made the constitution. When Jammu and Kashmir constitution is framed, then, in my opinion, the Proviso subclass 3rd of Article 370 has gone. That has no scope.
We'll wrap it up now. Thank you very much. Yes, now Mr. Beg.
With one submission at last.
Please give Mr. Beg
with one submission.
Yes.
We hope that this impugned actions, impugned orders may be quashed, and question of 4th August may be restored to the state of Jammu.
Yes, Mr. Beg. Second. बताएं उनको.
My lords, I must express my gratitude for you to give me some time. There was some misunderstanding. I had an advocate on record about a month back, and he didn't inform me that he had withdrawn. So I had to make very urgent arrangements. And the kind of assistance which this honorable court deserves. In one day, I could not really come up to that standard. My Lord, before I go to the present petition, I must inform my Lord that this issue had come in 1982. There was a conflict between two parties in the Legislative Assembly on whether Article 370 should be made permanent or is it only transitory, temporary, because the sideline says temporary and special provisions. 370 has three temporary, transitory positions. So, my Lord, there is a history behind that, why it was called 370 temporary, because either they were bound by our misfortune. Our Prime Minister had gone to United Nations with this issue about Kashmir, and they had passed a resolution, and they had said you should have a plebiscite. That resolution is still there. Thanks Lord, nobody is now after that United Nations resolution. It's for that reason that it had been called temporary. That's the only reason. Now, my Lord, I'm seeking your Lordship's permission, first of all, to refer to a scholar, A.G. Nurani. I know him personally. He had taken the permission from the Prime Minister to go into the archives and take out the documents which were confidential. And then he, my Lord, wrote this book. It was not out of imagination or out of some sources like me and others or some politicians. It was with the sanction of the government of India that he had access to these arguments, my Lord. Now, I first of all, my Lord, if your Lordship have volume 20 books -F, I'll be reading from that. I think your Lordship have that. Volume 20 books -F.
What PDF page will that be?
It says, my Lord, article.
Yes, you got that. It's at page 1, volume 20. That's Mr. Nurani's book.
Yes. Article 370 of the Constitution of India relating to the state of Jammu and Kashmir. Jammu is missing, is now, that time it was 60 years old, now it is much longer. The Constitution came into force on 26th of January 1950, which our children celebrate every year, this 26th of and 15th of August. 26th of January 1950, and with it, this unique provision. All other provisions were debated in the Constituent Assembly of India after deliberations in its drafting committee and sometimes discussions in the Congress Parliamentary Party. Article 370 was discussed for 5 months by the Prime Minister of India, Jawaharlal Nehru, and his colleagues with the Prime Minister of Jammu Kashmir, Sheikh Mohammed Abdullah, and his colleagues from May to October 1949, and then the reference is there. The state of Jammu and Kashmir is the only state in the Union of India which, my Lord, negotiated the terms of its membership with the Union. The reason for that was Mr. Jawaharlal Nehru's Security Council resolution which said that status quo should be maintained till they decide which party is right. The Constituent Assembly merely put the imprimatur of its approval on 17th October 1949 to a draft agreed between the Union and the state. Article 370 records a solemn compact. Neither side can amend or abrogate it unilaterally except in accordance with the terms of that provision. The Union Home Minister, your Lordship may forget that, And move on to the next one on page 2. A little over a decade after, it is the second paragraph, a little over a decade after the enactment of Article 370, its co-architect, Prime Minister Nehru, declared in the Lok Sabha on 27th of November 1963 that Article 370, within quotes, has been eroded, if I may use the word. And many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. And that integration was not only constitutional, it was also emotional. It was also based on certain principles. Kashmiris rejected the idea of Pakistan. Some fresh steps are being taken, and in the next month or two, they will be completed. We should allow it to go on. What had happened in the next couple of months, Sheikh Abdullah was arrested. We do not want to take the initiative in this matter and completely put an end to Article 370. That was in his mind that in some form or the other, it should stay there, maybe for emotional reasons. There was no need for that, as the Union Home Minister Gulzari Lal Nanda explained in the Lok Sabha on 4th of December 1964. The only way of taking the Constitution of India into Jammu and Kashmir is through the application of Article 370. It is a tunnel. It is through this tunnel that a good deal of traffic has been passed. It is a one-way tunnel, and we are not unhappy with that. He pointed out that while the normal process of constitutional amendment is subject to stringent conditions, the process of amendment made available under Article 370 is very simple. It's a pragmatic approach. Why to have a constitutional amendment from time to time? If you can pass an executive order through 70, why not resort to this? Sorry, sir. In regard to the rest of India, if a state's power are to be curbed and correspondingly those of the Union enlarged, the elaborate procedure laid down in Article 368 will have to be followed. In regard to the state of Jammu and Kashmir, Nanda argued a mere executive order made by the president under Article 370 would suffice. His successors in office accepted this interpretation of Article 370. Except, my lord, as your lordship will see, that is a tunnel. It is a tunnel, all right.
It appears that Mr. Nurani's thesis is substantially in terms of what Mr. Dwivedi argued. Because Mr. Nurani also says that once the Constituent Assembly of J&K was dissolved and the Constitution was framed, then Article 370 came to an end. And then everything he says that happened thereafter is unconstitutional.
Yes, my lord. I endorse that, madam. Nanda concluded what happens is that only the shell is there. Article 370, whether you keep it or not, has been completely emptied of its contents. Nothing has been left in it. Now, your lordship may kindly turn to is it page 3 and para 2. The Indian Independence Act empowered the Governor General of India to adopt the Government of India Act 1935 as the interim constitution till the enactment of a constitution by the Constituent Assembly of the state. That act, as adopted, served as a constitution from 15th of August 1947 to 25th of January 1950, my lord. Then, my lord, the last 5 lines of this page, the Governor General had written a letter, stipulated that as soon as law and order have been restored in Kashmir and her soil cleared of the invader. No, some years back, those invaders came, my lord, as not just invaders, but as militants, but as terrorists. the government of India made it clear that they would regard it as a provisional until such time as the will of the people of the state.
What is the drift of what you're arguing? I mean, what is your contention? What is your submission?
My submission, my lord, is finally this, that when all these documents and orders are studied, the abrogation of the state assembly, the abrogation of all its institutions, abrogation of Article 370 is unconstitutional, unnecessary. It's just a political gimmick. That is, my lord, the pith and substance of my argument. Then, my lord, clause 7 of the instrument of accession will show that in the beginning, our accession was on one extreme. And now it has gone from the one extreme to another extreme. In the beginning, my lord, according to the white paper on Jammu and Kashmir, published by the government of India early in 1956, recorded, in accepting the accession, the government of India made it clear that they would regard it as purely provisional until such time as the will of the people of the state could be ascertained. Lord, then I might, Lord, go to the next page, the second para. The state had acceded to India 1947 in respect of only of defense, foreign affairs, and communications. Negotiations were held on 15th and 16th of May 49 at the Deputy Prime Minister Vallabhbhai Patel's residence in New Delhi on Kashmir's future setup. Nehru and Abdullah were present. Foremost among the topics were the framing of constitution for the state and the subjects in respect of which the state should accede to the Union of India. On the first, Nehru recorded in a letter to Abdullah on 18th May that both Patel and he agreed that it was
possible to formulate, because you formulated it in your submissions instead of really reading us through Mr. Nurani's book. We'll certainly look at Mr. Nurani, the book, and all the other material which has been given to us. If you could just formulate now your points really, because a lot of this ground has been covered by the council preceding you.
Yes, my lord. Okay.
Almost everything has been covered.
It is submissions, but anyway, I think since my lord want to go to the bottom of it, but in a very short, my lord. पेज है इनके पास
In fact, we made a request.
No paper, please. Yes.
My lord, before I go to this, my lord, the written submissions, I have also written submissions. In this issue arose for the first time in Supreme Court of India in 1982. In a presidential reference, my lord. There was a dispute in the Legislative Assembly of Jammu and Kashmir, which was also its constituent assembly. A dispute arose whether Article 370 should be changed or modified. That was the issue. My lord, this it went to the Supreme Court. At that time, my lord, I was vice chairman of a political party, and I submitted, my lord, a written note. It is here, my lord, I'll pass it on. In this, my lord, if your lordship see that after your lordships heard us, the simple order was, we don't think it necessary to intervene in this matter. And that's how it stood. That's why nobody was bothered about it. After about every month and every 2 months, one entry or the other was, my lord, brought through Article 370 into Jammu and Kashmir. And when Sheikh Abdullah objected to it, my lord, he was sent to prison for 19 years. And his deputy, Bakshi Ghulam Ahmad, was taken into confidence. When he stopped playing the game, he was removed. And Bakshi Ghulam Ahmad Sadiq was made the chief minister, without majority. No, my lord, this is a tragic story. And finally, it has landed here in this August House for a final say. If this article, as some people have said, my lord, that this article is useless, but there is something more than bread and butter for human beings, whether they are people from Jammu and Kashmir, Jammu or Kashmir or Ladakh. They have, my lord, they were born with the idea that somehow we will be well protected, we have special rights under 370. Article 3 was amended by the impugned legislation, and totally contrary to the provisions of Article 370, Ladakh, Jammu and Kashmir was broken into 3 parts. Governor was replaced by Lieutenant Governor, who is a gentleman of the highest order. There's no doubt about that. But how can 370 be abrogated? What was the mechanism? First, ask the governor to dissolve the Legislative Assembly of Jammu and Kashmir. For what reason? Nobody knows. He just passed the order at around 12 o'clock at night. The certain orders were then issued by him. After some time, he was transferred without any reason and sent to a God-forsaken place. And what he said thereafter, I didn't bring it on record. This is step 2. What is step 3? You pass an order by virtue of which the Constitution of Jammu and Kashmir is abrogated. And you pass that order under Article 370. After that, what's the next step? You abrogate Article 370. Now, I'll pass on the documents to my lord, if your lordship are pleased to, all the documents which are, my lord, necessary. If I really go into details, my lord, I will take more time than my class fellow, Mr. Kapil Sipal, had taken. But since your lordship have set a deadline, I must accept the humility and say that thank you very much.
Thank you so much. Thank you. Thank you, Mr. Day. Thank you very much.
On record.
Thank you, Mr. Day. Thank you, Mr. Day. Mr. Shankar Narayan, what will be done?
If cannot be, permit me.
You're now the final counsel on your side. We'll give you half an hour from 2 to 2:30.
My lord, have information to place on record.
Why don't just Mr. Shankar Narayan just tell the nodal council to circulate what Mr. Beg gave. Just circulate it in the form of
the earlier advocate.
no difficulty. No, we have a nodal council who will scan it and just make sure that it's on our record. No,
These orders from my lord.
no difficulty.
Actually,
Naturally. So, Mr. Shankarnar, we'll hear you 2 to 2:30, but precise, I know you'll be able to do it in half an hour and then. Yes? You want the temperature to be increased a little?
Yeah. Every one of us, it's very chilly.
All right,
The warmth of the argument.
My lord, their attendance may be recorded.
Certainly,
Their
of course.
presence may not be.
We'll be back at 2 o'clock. Thank you, Mr. Baig. Yes, Mr.
May it please, Manoj. Manoj, may I first express my deepest gratitude for the immense patience that you've shown to all of us on the petitioner side. You've not cut us short terribly, and you've allowed us all wide leeway and latitude, so I'm grateful for that. Manoj, I appear in writ petition 1068 of 2019 on behalf of Soeb Qureshi. Soeb Qureshi is an advocate on record of this court as well. He's from Kashmir. There are a large batch of petitions before my lords, which includes people who are not only from Kashmir, who are not only politicians. It includes a former Home Secretary from Kerala. It includes professors, educationists, etc. The reason why I mention this is this case, the way we see it, is not a case only for Kashmir or Kashmiris. It actually opens a vista to many multifarious abuses that the executive can heap on the constitution if the means that they have adopted were to be utilized in future as well. There is a principle called obsta principis, which means that whenever anything that is approaching or encroaching upon our rights starts, you must nip it in the bud. That's the reason we're all here. Because this is an encroachment on something we cherish the most, which is our constitution. Kashmir is just an example or an avenue for how that is done. And I will seek to demonstrate how that is. Now, your lordships were right when you said I've been here for 12 days, but your lordships have also been here for 12 days. So I've seen all the arguments that's come before mine, which is why I've managed to cut and crop a lot which has already been covered. I will largely be adopting the arguments that have been made by Mr. Chandradeh Singh and Dr. Dhawan and Ms. Nitya Ramakrishnan. I just wanted to tell your lordships before I start that there are some documents which I won't take your lordships through, but you may note it. I mentioned this on the last occasion, which will, I think, benefit the court when eventually you are drawing your conclusions, my lords. Mr. Ramachandran had at length gone through this matter, and he created two lists of dates, a short list of dates, which is at page 17 of the written submissions, volume 1, and a long list of dates where he extracted from every single document the relevant part and put it together. That's at page 32 of the long list of dates. So page 17 is the short list of dates of the written submissions, volume 1, and page 32 is the long list of dates.
The long list of dates is what Mr. Sibal took us.
No, it's different. This is different. This is from Mr. Ramachandran's submissions.
Right, this was volume, page 32 of
written
volume
submissions,
2.
volume 1. Mr. Sibal's is written submissions, volume 2.
All right.
So in written submissions, volume 1, you have page 17, which is short list of dates, page 32, which is long list of dates. Then, my lords, VP Menon's book on integration of Indian states, Mr. Prashant Sen referred to yesterday, a couple of pages. I wanted your lordship just to note that there are two chapters. One is chapter 20, which deals specifically with Jammu and Kashmir. A most remarkable man. If you see his writing, despite him being first person there, you would never find any value judgments being made. It's only purely descriptive of everything that took place. So chapter 20, which starts in volume 15, PDF page 1257. Volume 15, PDF page 1257 is chapter 20, and at PDF page 1304, same volume, is chapter 24. Now, the second chapter deals with how the actual integration took place, the mergers, accessions, etc. The third document, which I think would benefit, my lords, is the white paper. Now, the white paper is the entirety of volume 4. So documents volume 4 is the entirety of white paper. My associates, in fact, have gone through them para and verse and have created a table.
Above para 224, there is that chapter on territorial integration.
Territorial integration, exactly. Now,
just give me that reference again.
That's white papers volume 4, my lords, the entirety of volume 4.
Yeah. That's 1951.
Yes, no. Then this is not part of the compilation, but Granville Austin's book on the Indian Constitution, which is the first book, now Working of the Democratic Constitution, second one. But the first one, which is definitely there in the libraries,
Cornerstone.
is 243 to 254.
Just repeat the pages again.
Pages 243 to 254, Manoj.
Of which volume?
It's
you're
not,
referring
it's
to the
not,
original, you're referring to the book.
It's the book separately. Now, one separate point, just because we are on this history bit, Manoj, the Chief Justice yesterday asked for the background of the Union Territories, and we were trying to assist. In NDMC, the 9 judges judgment, Manoj, which is on record, it's PDF page 229, volume 14. Volume 14, page 229. From paras 8 to 19, the entire background and sequence of how we came up with the 7th Amendment and the Union Territories is there, which deals with 1919, the 1935, Chief Commissioner's Provinces, all of. So that I think is helpful.
Paragraphs
8 to 19. I'm sorry.
8 to?
8 to 19.
Which page?
That's page 229 of volume 14. Whoever has volume 14. Lastly, again on that point, yesterday, Malad, we had shared the photos of that original constitution with the schedules.
Yes.
Now, if you noticed in the schedules, they keep referring to section 290A of the Government of India Act, because all those are states which have been added by virtue of section 290A. Now, strangely, it's not part of the Government of India Act, which we have as part of our documents, but it is part of the white paper. So in the white paper volume, PDF page 77 is where your lordship will find section 290 capital A, which was inserted for that purpose. Because I'm appearing for an advocate, I feel it was my duty, and this is what the instructions I have from aforementioned advocate, to ensure that, my lords, we must be careful when we are assisting a constitution bench to ensure that the court avoids pitfalls. Now, it would not be fair of us to present a case which is not supported by the precedent or which the precedent has specifically squashed, which has happened, and I'm afraid I'll have to do that fairly unpleasant task of differing from some of the counsels who came before me on a couple of points. I want to clear that up right now. The first, Mr. Dwivedi, he made arguments, Manoj, with reference to 370 clause 3 not surviving, and the entirety of 370 therefore not survive, that the entirety of it had come to an end. Your lordships had said constitutional practice would trump that. There was subsequent constitutional practice. But I'm afraid this was the exact argument that was taken before this bench, and where your lordships passed the order in the Shah Faisal matter when the reference was sought. Now, the reason is Sampath Prakash, which is the 5 judges bench, had that argument taken before it, saying that 370 has come to an end. So you couldn't pass any orders after 1957 by advertence to 370 clause 1. Sampath Prakash squarely rejected it. And when, in fact, a couple of our colleagues had wanted to have that reference, we also argued, as did the government, that it should not be referred. There's no conflict. This position is fine by us. So in fairness, I must tell your lordships that the Shah Faisal judgment is in volume 17. It's PDF 42.
Could you repeat that again, please?
Volume 17. Case law volume 17.
Yes.
PDF 42. The extract of Sampath Prakash is at para 40. And Sampath Prakash's reasoning is that CO 44, which was the 1952 CO, if your lordship will remember, that was the one issued under Article 370, Clause 3, the 1952 one. Thereafter, in 1954, with the Constituent Assembly, they issued 371D, the 1954 order. Now, the 1952 order is proof of the fact that the order itself says that we allow 370 to continue to stand except for this modification and that explanation. Your Lordship will remember yesterday that explanation much was being made of it. So it was the conscious choice made at that point in 1952 by the Constituent Assembly, because that's the threshold. That's when we are going to go ahead and make the Constitution. Now, if we are going to activate 370 clause 3, why embark on this exercise? We get the entire Constitution to apply. But because they made that conscious choice in 1952, they issued that, the one and only order that's ever been issued under 370 clause 3 until 2019, which is the 1952 order. Now, that 1952 order is the reasoning adopted by the Sampath Prakash bench to say, since you yourself have taken the decision that the Constitution of India will apply with exceptions and modifications, and the only exception or modification you have brought in is that explanation, which was a question that fell in Damnu later. But because you yourself have said that, it's an accepted fact that 370 continues to apply. That is your conscious choice. I'm corrected to say it's a declaration, Malans, not an order. It's a declaration under 370 clause 3. And at para 44 of Shah Faisal, para 40 is where this extract of Sampath Prakash is. CO 44 is referred. And at para 44, your Lordships have given that as the reason why you're not referring this to a larger bench. The third reason given in para 44. The second, again, I'm afraid of, I'm sorry for the broadside, but I have to be accurate on this. Article 357, there was an argument taken by Mr. Parekh yesterday. And he was saying the part of it doesn't apply. In fact, it does, which, if your Lordships recall, how they issued these orders under 371D was they chose the part and said the part will apply, subject to A, B, C exceptions or modifications. So they would refer to the article under it and then make those corrections. If you compare page 18 of volume 3, which is the first order, when 357 was not made applicable, with page 38 PDF of volume 3, so that's 1952, I think, and 54 first, and then 1958. Now, page 38 is 58. They, while bringing 357 back, 360 is omitted. So 357 continues to apply fully. So it wouldn't be appropriate for us to argue that 357 doesn't apply in the state of Jammu and Kashmir. In any event, when you see volume 1, page 188, which is the documents dealing with how the Constitution of India applies to Jammu and Kashmir, that page you'll find 357 there, as it is.
Volume 1, page 188, right?
Yes, volume 1, page 188. So, my lords, the points that I'll deal with, I'll just unfold for your lordships. There are some which I've decided I'll leave for rejoinder. I won't trouble your lordships with that because that can come at any stage. It's not a particular thing that needs to come first up. On history, there are a couple of points that I wanted to make. In fact, I have put all my oral arguments.
Mr. Nurani, I was reading in the morning when somebody cited Nurani's book. Mr. A.G. Nurani has, of course, criticized the judgment in Sampath Prakash.
Yes.
On the ground that he says Sampath Prakash ignores the first judgment.
Correct. Correct. It is. That is the argument that was taken, seeking the reference. But since we
that has been now
that has been declined, I think we'll go by what the judgment
what
they say.
Yes.
So I believe those judgments do help us. There are portions of it which have already been read to your lordships. So I don't think I should trouble your lordships with that. Now, my lords, what I've done, I just want to let your lordships know, because I could share it with your lordship, but I needed your permission first. I've made a document of my oral arguments, which will, because I saw your lordships were grappling with going to volume and pages. So we have taken pictures of each page and put it in the note itself. So you don't have to go anywhere else. Plus, there are tables, including what you asked Mr. Zafar Shah, the comparison. So there's a 70-page document comparing the Constitution of India, Constitution of Kashmir, and Constitution of Jammu and Kashmir, showing what provisions would continue to apply, which may be different or in some cases better, as far as Jammu and Kashmir are concerned. Now, I have the document here. To make it easier reading, if I'm permitted to share that with you. Otherwise, I can just do it like this, because I know your lordship, this is not a written submission. There are no arguments here.
Okay, you can.
Rather than going to and fro from documents and volumes, it's all put in one place.
And you have it in the soft form?
I have
soft copy? Okay.
I have the soft form. It's ready to email if I can do that.
Right, we'll ask. So we'll label this now. Fixed, right?
Yeah.
So one-page note is not a problem, but if it is something to...
No, it's not written submission.
Because we would have done it ourselves, but if anything...
No, I'm saying I put pictures, but only reason is your lordship...
Pictures from the existing compilation. Right?
In every place, I put volume and page number, so your lordship can see it's from that volume and page number. There's no arguments. No arguments at all. It's just the sequence of...
Just putting it everything in one place.
Yes, in one place. And for the annexures, which is as per, everything here is a response to the questions that came from your lordships the last 12 days. Everything. Except one last segment, which is completely different, but everything else. Which is why it's only a response to the questions. I think we have to assist your lordships now. So, it's been sent, so it can be shared.
Chetan, mila hai kuch?
Meanwhile, I'll just explain to your lordships how I'm dealing with it. There's a little bit of history, and one I think which is very important, which is the previous attempt in Parliament to omit Article 370, in which there were debates in detail. And Mr. Gulzari Lal Nanda, who was the Home Minister then, this is between his 2 tenures as interim Prime Minister, he as Home Minister says that there is no way that we can go ahead and repeal or omit Article 370.
Durrani is also referred to that part.
Yes. In fact, I think just before me, Mr. Beg referred to that tunnel that came from that answer to that debate. So the history, I think some aspects of this history may be relevant to be looked at. Also, some of the speeches given in the Jammu and Kashmir Constituent Assembly, you've seen a few, but I think it rings true. All of them repeatedly are so happy, and they always say there are applause and there's cheers about the fact that they joined India. There's no question about any kind of secession, any second thoughts about it, etc. The fact that Sheikh Abdullah in 1972, after his prolonged incarceration, when he was to come back and form the government, they entered into an agreement, Sheikh Abdullah and Mrs. Gandhi. And it's interesting because that agreement provided for the fact that there'd be no question of you asking for an abrogation of 370 clause 3. The accession is absolutely complete. No secession arguments can be taken. That's also put on record, the Sheikh Abdullah and Indira Gandhi agreement. Interestingly, Indira, on behalf of Mrs. Gandhi, the signing of that agreement, which happened the day before he took over as Chief Minister, was done by Mr. Parthasarthi, who was a famous diplomat, but also was the son of Gopal Swami Iyengar. Many ways that you find overlaps throughout. But this history, I think, shows and resonates how from then, that date till now, the interpretation of 370 has been consistent without any departure. 370 clause 3 is the temporary provision. A choice had to be exercised at that point of time, which was done, and it was over and done. And the problem is the other way around. If I may just digress for a minute. 370 clause 1 says Article 1 will apply. You can't make any changes to it. And it starts with a non-obstante clause. 370 clause 3 also starts with a limited non-obstante clause, which says notwithstanding anything in the provision above. We are looking at it throughout while the arguments are on, with reference to the question of complete integration or the constitution completely applying. Why don't we look at it the other way around? Suppose you had some government at the center, which for reasons best known to them, have a sympathy to the cause of secessionism and say that, look, we will artificially create some assembly to be treated as the Constituent Assembly. They will take a decision whether 370 clause 3 can be utilized to abrogate 370. Now, when you abrogate 370, please note that Article 1 also goes with it. The other way around.
There is a problem, Mr. Shankanarayan.
Yes.
Article 1 is a permanent feature of the Constitution,
Absolutely.
right?
Absolutely. Yes.
Now, what was the reason for Article 370,
Yes.
Clause 1,
Yes.
to contain a specific reference that Article 1 of the Constitution shall apply?
Yes.
Article 1 of the Constitution was in any case applicable because that's an embedded part of the Constitution.
Absolutely.
The reason why they introduced a reference to Article 1
Yes.
in the in Article 370 was for this, that during that interim period when there was a power to modify the provisions of the Constitution,
Yes.
those relatable to the instrument of accession with consultation,
Yes.
those not relatable to the instrument of accession with concurrence.
Yes.
During that period, there would have been a doubt as to whether or not Article 1 could also have been modified with concurrence. So the object of putting that in Article 370 was to redouble the constitutional statement that Article 1 is a permanent feature of the Constitution.
Yes.
Now, if Article 370 was intended to be permanent,
Yes.
there was no reason to include Article 1 in Article 370 because Article 1 anyway is a permanent feature of the Constitution.
Absolutely, right?
Just one more.
Yeah.
You see, when we refer to Article 370, Clause 3,
Yes.
it only refers to 370.
Yes.
It doesn't refer to Article 1.
No, it doesn't. Correct. Correct. But 370, which includes within it Article 1 compulsorily applying.
But that if one looks at it, the argument which you raised, if one looks at it, what you can abrogate is Article 370.
Correct.
Not Article 1.
That's what I'm
So
saying.
370 goes, the entire Constitution becomes, as it is applicable to all the states, will become applicable to the state of J&K.
Which is why, if I may just read that,
If-
and
if
this
suppose-
is not my interpretation, this is the President of India's interpretation, Rajendra Prasad's. His letter is here, I'll show you the extract. His interpretation writing to Pandit Nehru. But allow me to just show your lordship for a minute, 370.
You will never attribute to the Constitution
Yes,
the use of a surplusage.
absolutely.
Right? Every
Absolutely.
word in the Constitution, we apply that principle to an ordinary statute of the legislature.
Yes,
More so to the Constitution that you would never attribute to the Constitution makers any intent to use a surplusage or something without meaning.
absolutely.
And the reason why Article 1 is specifically referred to in Article 370 is
Yes,
that during that interim period, while other provisions could have been modified, it's very clear that Article 1 will not be modified.
absolutely.
Which is a clear indicator of the fact that 370 was never intended to be permanent.
I'm with
Probably your argument could be
No, I'm with you.
that after the Constituent Assembly arrived at an understanding, something further was left to be done by the Indian Constitution.
So
Now, which was never done, and we followed this expedient of the COs.
Yes.
That's what seems to have happened.
Yes.
It served everybody's purpose. The government of India could get the work of the government done. The J&K Assembly could have those beneficial provisions of the Constitution apply to them.
Yes.
As the then Prime Minister Nehru said, that's now reduced to a shell.
Yes.
That's what he said.
That's true.
Now, as a result of what this seems to have, therefore, been a very convenient expedient of having COs to apply the Constitution to Jammu and Kashmir and progressively bring J&K into the mainstream
Yes.
and integrate it fully
Yes.
on whatever issues that were left out.
Yes.
But possibly, these are clear indicators within, intrinsic to Article 370, that these were in the sense of pro tem provisions until some further action would be taken.
This is absolutely right. In fact, if your lordships would see from 379 onwards, fortunately this book is there now. They've all been repealed, 379 to 390. Those were also pro tem provisions dealing with the provisional parliament. In fact, the converse of
Yes.
the converse of what was shown to your lordships earlier about the explanation provided in Jammu and Kashmir of where the Constituent Assembly of Jammu and Kashmir would conduct itself as the legislative assembly. The identical provision is Article 379, which stands repealed, which is that the Constituent Assembly of India would be the provisional parliament and they would elect the President of India for the time being, etc. Now, those are pro tem provisions. I'll show your lordships that in detail. But on this point, the question provisions of this article. Now, that I think segues exactly with what my Lord the Chief Justice said. Wouldn't this be surplusage? What was the need for these words? the need in my view for these words, because what is it in the provisions above that are standing in the way of 370 clause 3? It appears that 370 clause 1 has excluded the possibility of Article 1 and Article 370. 238 anyway had gone by that. Of these two provisions being in any way the subject matter of orders under 370 clause 1 subclause D. It had excluded it. What 370 clause 3, and I have to look at it keeping two things in mind. 2023, when I'm making this argument, and the fact that Sampath Prakash as well as your lordships have held that this position of 371D being operationalized is the position, that's a correct position, there's no way of questioning it. If I keep those two parameters in mind, the Constituent Assembly sitting in 1952 is faced with the choice which is provided under 370 clause 3, which is that notwithstanding anything in the provisions above, you have to decide whether you want to keep 370 alive in some form with exceptions or modifications, or do you want to junk it as a whole? Now, if they were to take that other choice, and we're grateful that they didn't, but if it was a question of doing so, what is the impact on the Article 1 not being made applicable? What is the impact on it? The way I see it, the impact is, and it's an unfortunate answer, the impact is that Article 1 wouldn't apply to them if they had decided so. And it, in my view, that's the danger of recreating a Constituent Assembly at any point. Article 368 in our Constitution doesn't permit repeal of the Constitution. Please see. It says amend, modify, repeal any provision of the Constitution, not the Constitution itself. And after the basic structure has come, there's no question of that. Now, what is our fear with this Constituent Assembly argument? It would be very difficult for this court to give a verdict on the Constituent Assembly being resurrected as far as the state of Kashmir is concerned, and in a future date tell us that no, that's a principle that applies to Kashmir, it doesn't apply to the Constituent Assembly of India. My view is it applies squarely to the Constituent Assembly of India. There is no question of suddenly reviving or resurrecting the Constituent Assembly of India in any fashion. It's done for. What you want to do, you do by amending this Constitution. This is something we and our forebears have tied ourselves down to. That's the idea behind the basic structure. There is no way of incremental modifications being made by virtue of resurrecting Constituent Assemblies. This case is effectively about, one, whether a power exists, and two, has the procedure laid down for the exercise of that power been followed? In Article 3, for example, there's a question that Justice Kaul put to Mr. Chandrodaya Singh yesterday. Converting a state into union territory is a lack of source of power that doesn't exist in the Constitution. It can't be done. But, subject to what Justice Kaul said yesterday, can you take a part of a state and convert it into union territory? Yes, you can. Article 3 provides for it, but there is a procedure for exercise of that power. That procedure has not been followed. I hope I'm making myself clear. So there's a source of power, whether it exists or not. And then there is the exercise of that power. The same argument applies to Article 370. Does the prospect of creating a Constituent Assembly exist today vis-a-vis Kashmir or vis-a-vis India? No. My answer is a square no. That's not provided for in the Constitution, therefore it doesn't exist. In any event, and without prejudice to that argument, the exercise of the power and the manner of exercise of that power is one of the most fraudulent, invidious exercises that we have seen in this country since 1970. And why do I say 1970? In 1970, when they wanted to get rid of the Privy Purses, they moved a Constituent Assembly bill, amendment bill. That bill went to the Lok Sabha and passed through the Lok Sabha. It went to the Rajya Sabha and it was defeated by one vote. One vote. And then what did they do? Overnight, the President issues an order under Article 366, definition provision of the rulers, and uses that power to say from tomorrow onwards, there are no rulers, all your Privy Purses. What have they done differently today? They just use the next provision. They use 367. and your lordships came down like a ton of bricks on them. 9:2 you held against that kind of an action. And I want to show your lordships Madhavrao Sindhya because I believe it squarely applies. They finally had to go back to the drawing board. They had to come with a constitutional amendment. That constitutional amendment was sustained in Raghunath Rao Ganpat Rao 20 years later. But the fact is, following procedures laid down in the constitution are sanctified mechanisms which protect us, which protect this constitution. The sovereignty doesn't go to the executive. The executive is a creature of the constitution, as is this court. The people are the sovereigns under our constitution. Let there be no doubt about that. Because I believe that there is some feeling, which is the same feeling that the government had at the time of Madhavrao Sindhya, that some level of paramountcy, some level of sovereignty had devolved on the executive. So an executive has some residue power by which they will interpret the constitution differently. They will use definition clauses where they can't touch it directly. My Lord Justice Khanna on day one was considering the proviso to Article 370 and said, look, that's a proviso. But the proviso is perhaps the most important thing in this constitution. Constitution amendments in this country have been struck down on only two grounds, only two. One was basic structure, the other was a proviso. The proviso in 368(2) was the reason why in Quixote Holohan, para 7 was struck down. Again, the amendments that were brought in for cooperative societies, your lordship struck down because it didn't meet with 368(2). I remember, my lord, the Chief Justice mentioning on day one about 368(2) proviso. Can you use that by way of the 356 route? I think that's a fantastic question. That's the heart of this case. Can you do that? Can you use 367? Can you use 366? Can you go sideways? The proviso provides the procedure you will follow. And you, creature and servant of the Constitution, will use no other procedure. We are not sitting here in deference to our equals. Our elected representatives have taken a choice. They've made a choice that they will follow the Constitution. Their oaths bind them to it. And they decide to follow devices like this. And they possibly don't learn from the lessons of the past. And I want to show your lordship the language of Justice Hidayatullah, Justice Shah in majority, Justice Hegde concurring in Madhavrao. It completely, in my view, covers this case fully. It's the exact same thing. In fact, it's less complicated, less experimental. But I'll come to that. That's the history part. On 370, because these words are very, very important in our Constitution. We can't read them as out of context specific provisions with specific words. The words temporary, the words consultation, concurrence, necessary, recommend, the non-obstante clause, even the colon. There are 3 colons in Article 370. All of these are found in other parts of the Constitution. So if your lordships were to look at this provision in isolation and interpret it without at the very least considering the other provisions where similar words are used, we would have a problem that will arise on a future date, which is why I want to address your lordships on those. Then on the frauds on the Constitution and the measures which keep those provisions intact. 3 of them in particular. The ordinance making powers, which are exceptional. The expressions your lordships have used are necessary evils, but with safeguards. And what is that safeguard? That it will be temporary. Immediately after the legislature comes in, the legislature will look at the ordinance and decide whether they want to continue or not, as they have done in recent weeks, as far as the NCT of Delhi is concerned. Article 356, about how it will be exercised. There are safeguards in the Constitution. And see the orders they pass under 356. They suspend the legislative assembly. Once they suspend, and suspend has no other meaning in law. It has absolutely no other meaning in law except that it is for a fixed time period. It's in the interregnum. It's between 2 things. I haven't terminated. I haven't ended, killed, murdered, buried at 9 feet, 6 feet under. I haven't done any of those things. It's just suspension. What is the effect of that order today? Exercising 356, they suspended the Legislative Assembly and poof, disappeared. What's happened to it? These are series of abuses of the Constitution which has taken place in this case. And finally, my lords, there is one aspect which I thought is interesting and disturbing at the same time. In 2018, coincidentally, just a month before the events which transpired here began, our friends across the border did something unusual. Pakistan occupied Kashmir, they have another name for it, and Gilgit-Baltistan are the two areas which Pakistan claims as its own. In their constitution, there's no reference to that as part of their territory. And I think advisedly so for their sake, because they still harbor some hopes that there would be some accession of Kashmir to them. In 2018, they decided, one, to pass an amendment to their 1974 interim constitution for, as they call it, Azad Kashmir. The other thing they did was in the same month, they decided to pass a GO with reference to Gilgit-Baltistan, which is the other area which is also across the border, all part of erstwhile Kashmir, or continues to be part of Kashmir. In fact, Section 47 of Kashmir Constitution, you will find a reference that the territory of Kashmir as defined in the Constitution is the territory as it was on 15th August 1947, which is the entirety of it, without the 75,000 square kilometers having gone to Pakistan. Both that amendment and that order, what it did was to take away the right of self-governance that the people in those two areas had and to vest it in themselves. As far as Gilgit-Baltistan is concerned, it was challenged with the High Court. High Court allowed the challenge. It was reversed by the Supreme Court, which strangely substituted the impugned order, which had been passed by the government, with an order of its own. Effectively, what the government there has done is to wrest direct control and vest it in a council with the Prime Minister. I ask myself that question, isn't India different? Are we not a democratic country run by a constitution? Do we not adhere to certain promises that we make and which are covenanted in the Constitution as a solemn promise on which 5 constitution benches have weighed in? Or are we going to follow the ill-advised example of people who put their prime ministers in jail? Now, if your lordships have that note, I am not sure if it's been uploaded.
It's got it there.
Sorry. If your lordship can then just skip quickly down to page 2, my lords. I won't take long. I've just given the outline already. From page 2 onwards, I'll just quickly read out the headlines. This is the sequence in which things panned out. Cabinet Mission Memorandum on State Treaties and Paramountcy, that was in May 1976. The second para there refers to how the rights returned to the states from the Crown. This is important, apropos what your lordship said. So what the British Crown had taken, the British Crown gave back to the states. So after that, it was between the states and the new government of India to enter into whatever arrangements, which is why the Government of India Act 1935 had to be amended. This is echoed by the Cabinet Mission at the bottom of that page. Next is the Negotiating Committee. This is on behalf of the Princess. Yeah, asking. That's point number C. Then Mr. Vallabhbhai Patel's statement in July, a month before independence, my lords. If I can read the last 3 lines of the first paragraph and the second paragraph. We ask no more of them than accession on these 3 subjects in which the common interests of the country are involved. In other matters, we would scrupulously respect the autonomous existence. Next para, last 3 lines again. Nor would it be my policy to conduct the relations of the new department with the states in any manner which savors the domination of one over the other. If there would be any domination, it would be that of our mutual interests and welfare. Then the Indian Independence Act, these are the two relevant sections. Then the Government of India Act, the amendments I've referred to, my lords, that's 5, 6, 290 and 290A. H, this is the three routes which are set out in the white paper. H, the integration of states did not follow a uniform pattern in all cases. Merger of states in the provinces geographically contiguous to them was one form of integration. The second was the conversion of states into centrally administered areas. And the third, the integration of the territories to create new viable units known as unions of states. Each of these forms has been adopted according to size, geography, and other factors relating to each state or group of states. If your lordships were to tap on refer table 2, it will take you to a table. If you just tap on that. Now that table splits these states into three types. States that envisage their own constituent assembly, which are Madhya Bharat, Pepsu, and Rajasthan. Second, states that ultimately formed a constituent assembly, and there are quite a few of those. There's Mysore, Jammu and Kashmir, Junagadh, Saurashtra, and Travancore and Cochin. So because this question of constituent assembly came up, your lordships need to know that there were these 4 states which had constituent assemblies, but how 3 of them decided to go ahead with the Indian constitution after extended negotiation. The 4th one was Jammu and Kashmir. The table below shows your lordships each, I'm sorry, my Lord Justice Call has that? Yes. The table below has princely state, the date of the instrument of accession and a supplementary instrument, if at all, the constituent assembly, if any, the remarks against that, and the source. I've given your lordship the volume and the PDF number. And we have shown how Jammu and Kashmir is the only one where that constituent assembly went ahead and formed the constitution. I'm not going to take more time. Your lordships will see the table whenever you have leisure, my lords, if your lordships have any leisure. Can you click on back on top to take you back to the beginning? At the top of the page, it says back on top, on the top right hand. If you just tap on that, it'll take you back to the note. The next was supplementary instruments. I'm sorry. Access. Hello, Justice Gawa, you have the note. No, but I don't know if they each in them. But do even like that. Yeah. Okay. I'm sorry, could I assist if there's any difficulty? No, I don't know if we have in the. I think it's across. No, it's too big. Okay. Yes, Manoj, are you back?
Notes of arguments.
I'm not sure. Huh? Page 4, I think. Page 4. Okay.
After table 2.
After table 2. Yes. Supplementary instrument. I'm sorry?
States with constituent assemblies. That's para 2.
Yes. Page 4, Manoj, bottom. We, in fact, looked at the guidelines the court had issued yesterday for written submissions, etc., which says PDF and page number has to be the same. So we try to align that.
We're reading the white paper, no?
Yes, Manoj. That states with constituent assemblies, there are those 2 bullet points below that. 7 princely states. Your Lordships have that? Bottom of page 4.
BNRO committee.
Yes.
ये तो जो हम शो करते बोला लॉर्डशिप के पास आया वो पर्सनल किसी से थोड़ा टाइम लेगा कोई बात नहीं.
We saw Sardar Patel's statement. Now where are we?
Yes, bottom of page 4, states with constituent assemblies. Lordships have that?
Yes.
So these just give you the data points. 7 had covenants to form constituent assemblies, 4 formed them. And then the next page top, page 5 top, is the extract from the white paper. In existence, namely Saurashtra, Travancore, Cochin, and Mysore, the Saurashtra Constituent Assembly adopted the draft constitution in its entirety. The other 2 constitution-making bodies proposed a few amendments. Some of these were incorporated in the amendments finally accepted by the Constituent Assembly of India. Others were dropped as a result of discussion with the delegation of these assemblies. Our next para deals with Kashmir specifically. The state has therefore, I'm sorry, the Lordships have that?
Yes.
I'm looking.
Yes, the state has therefore been included.
The state has therefore been included in Part B states. In view of the special problems arising in respect of the state and the fact that the government of India have assured its people that they would themselves finally determine their political future, the following special provision has been made in the constitution and 370 is extracted. Your Lordships can see that first part of 370. Now, there is after that, from the J&K Constituent Assembly debates, Mr. Beg, speaking in the Constituent Assembly, also mentions why it is exceptional, why 370 is unique. Why was a special position, your Lordships have that bottom of the page. Why was a special position granted to Kashmir? It is because of its special character and the struggle for freedom which the people of Kashmir have led. Kashmir, sorry. Kashmir, sorry.
Kashmir.
Appropriate. Huh? The second sentence there, Kashmir, let me say, is the only state with this composition of population which chose voluntarily to accede to India, and we are happy about it. Within brackets, cheers. This is the first reason. Secondly, Kashmir has a strong popular movement behind it for which it fought for 21 years. That movement was for the establishment of communal harmony and welfare of the masses. Kashmir has before a definite socio-economic program of its own. As an honorable member of this house has said, it is with a view to implement that program that we acceded to India and we maintained special position. In order to implement that program by common consent and agreement during the time of Sardar Patel and other leaders. And other leaders of India, special position was given to us. Therefore, any question of having given this special position to us for a temporary period does not arise. It was never given to us because our question is hanging fire in the UN or because Pakistan put forward its right over Kashmir, but because of the reason I have mentioned. It is a special position, and taking it away will clearly be betraying the people of Kashmir. We made our mind clear to India, and I'm glad it was understood by the Indian government. Honorable members of this house have expressed their doubts as regards the residuary powers, etc. Then Dr. Rajendra Prasad's note as president. This is sent to Prime Minister Nehru on 6 September 52. There can be no doubt that Article 370, and particularly Clause 3 thereof, is of an exceptional nature. While it safeguards in Clause 2 the right of the Constituent Assembly of Jammu and Kashmir to revise or annul any action taken by the government of that state in giving concurrence under Clause 1B2 and the second proviso to Clause 1D of Article 370. It excludes altogether the Parliament of India from having any say regarding the Constitution of Jammu and Kashmir and places full power in the hands of the government, including the power to amend the Constitution of India. It is therefore necessary to examine the wording of this peculiar clause with some care for a correct application of the comprehensive terms that Parliament could never have intended that such an extraordinary power of amending the Constitution by executive order was to be enjoyed without any limitation as to the number of times on which it could be exercised, or as to the period within which it was exercisable, or as to the scope and extent of the modifications and exceptions that could be made. It cannot be seriously maintained that for all time to come, the application of our Constitution to Jammu and Kashmir would derive its authority from Article 370 to the complete exclusion of Parliament. The marginal note to Article 370 itself describes the nature of the article as temporary provision with respect to the state of Jammu and Kashmir. Please mark this note. The conclusion, therefore, seems to me to be irresistible, that Clause 3 of Article 370 was not intended to be used from time to time. The correct view appears to be that recourse is to be had to this clause only when the Constituent Assembly of the state has been fully framed. So it's a one-time exercise as far as 370 Clause 3 is concerned. I know it's troubling your lordships about 370 being a temporary provision. Our case, at least my case, 370 Clause 3 is a one-time decision-making exercise to be carried out by the Constituent Assembly. If abrogation is to be done, it's to be done once. And if it's done, 370 is out of the window, no problem. But if they did what they did in 1952 and decided to have their own constitution, 371D then continues to operate and has been utilized precisely like that. And that's why Sampath Prakash said it's permissible.
Kumalshankar, this,
Yes.
this entire version can be read differently also, against you also. That it was made as per Dr. Rajendra Prasad, that there will be, clause 3 will be adopted and applied by the Constituent Assembly, and it will be abrogated forever. It can be read that way also. If you read it, read it carefully, that's the.
Even if I were to read it like that,
that's the.
One thing is very clear.
If you read
He
it,
says
just
that it
read
can
now,
be used.
Just read what you have said.
I've read that. I've read that. So he is very clear about one thing, about taking out clause 3 and referring to it. That he's very clear about. He's also very clear about it not being used repeatedly.
We can't.
No, I'm saying there's no two ways. I don't think the President of India was under any misapprehension of what the Constituent Assembly of Jammu and Kashmir was.
If you read the first portion,
Yes.
probably the entire context in which he is saying is,
Yes.
there will be Article 370 will probably not see the light of the day after the Constituent Assembly of J&K.
The abrogation
exercises the power and the clause 3 of
it is
370.
temporary to the extent of abrogation. To that extent. To the rest of it, which is why 370 clause 2 is transitory. 370 clause 3.
I'm not for the moment suggesting what the interpretation should be.
No, I agree. No,
What
but it's food for thought, definitely.
What I'm only trying to point out is there are two ways to look at the speech.
Yes.
Context in which
Yes.
Contextual interpretation is to be adopted.
If your lordships were then to see the entirety, because what I've extracted is page 774 and page 778, 779. If I read the entirety of it, which will take some time, I don't think your lordship will be left in
examine that. We'll examine.
Yes, I leave it to your lordships to examine. Just see the whole letter. There's no doubt. There are three things that the president does. He takes out 370 clause 3, tries to understand its implication. He refers specifically to the Constituent Assembly, and he makes it clear that this is not a step that can be repeated. Those are three things that I adopt. Now, I have made a reference here, my lords. This is only because the entire history with reference to all these aspects were also culled out by Justice Hidayatullah in Madhav Rao Scindia's judgment. So I've referred here, but your lordship can just jot on the side, paras 5 to 15 of Madhav Rao Scindia, which volume? It's here only, volume 6. Volume 6, PDF pages 419 to 425.
PDF pages?
PDF pages 419 to 425.
That is Madhav Rao Scindia?
It's written here, my lord. Your lordship can see. It's volume 6. Starts at 420.
You need not do this.
Starting pages?
You need not do this.
Starts at 390.
Confine yourself to that other one.
Yeah.
6 pages.
Yeah.
It starts at page 390. PDF 390.
So, Mr. Shankaran, you've given us a 143-page note.
That's only a table. Your lordships, 60 pages of that is that constitution comparison. I'm not even going to take you through it. I'm just putting it because you need to have the material. Because all of this couldn't have come in our written submissions in advance. When your lordship put those questions saying we want to see the comparison, we had to respond to that. So I'm not going into any of that.
Now, how much more time, Mr. Shankaran?
I'll wrap up, my lords. I'll wrap up. I'm just going quickly. That's why I'm not showing your lordships too much.
So let's.
So this was primarily to show the unique nature of Kashmir. I'm sorry. In fact, it's interesting that for Kashmir, we had a ministry in the union government, the Kashmir Affairs Ministry, which was headed by Iyengar. But for everything else, it was Sardar Patel. And apparently there was a little bit of kind of discomfiture between the two of them about that. So Kashmir's unique position, and the reason why I'm saying this is because in the second NCT judgment, your lordships have unanimously looked at 239 AA and Delhi as being not just a simple union territory like the rest of them, but being a little different. I'm canvassing the same for Kashmir. It's very clearly different. There is a different arrangement. Its inception was different, its birth was different, its life has been different, it's got a constitution, it's been running 70 years. Now, if you're going to upset it on a mere ipsi dixit overnight, there's obviously some basic procedures and protections which are provided in the constitution have to be met. That's all we're saying. We're not saying that you can't do this, especially when we have reached this far. In 1908, I'm sorry to digress, But in 1908, in the marathon in the Olympics, there was an Italian man who was a male man who took part in the Olympics.
Yes.
His name was Dorando Pietri. Dorando Pietri reached, after finishing the entire 42-kilometer stretch, reached the stadium, and I think it was Paris. And he ran into the stadium, and then he was so exhausted and dehydrated that he was collapsing. So thrice, the umpires, referees, people who were standing near, helped him pass the finish line, and he came first. And then they stripped him of his medal. They said that you took help, and the rules don't permit you taking any help of any sort whatsoever. But he did running himself, and they disqualified him. The reason I'm mentioning this is pretty much where Kashmir had come with adopting India's constitution. We had entered the stadium, Kashmir had entered the stadium, it was near the finish line. There was an illegitimate assistance given to get it past the finish line, which is completely unnecessary. Completely uncalled for, contrary to procedure. You lose a gold medal as a consequence. Also, my lords, the promises that were made at the beginning of the constitution as against now. There was the people of Kashmir through the Constituent Assembly took the decision not to anyway adopt, exercise Article 370 clause.
Not, I mean, just as a hypothesis.
Yes.
It's sort of worrying me, and therefore I'm putting it to you at this point, maybe a little digression.
Yes.
Can we not possibly read Article 370 as indicating two terminal points?
Yes.
The first terminal point is in clause 2 of Article 370, namely the formation of the Constituent Assembly of the state for the purpose of framing the constitution.
Framing the constitution, that's correct.
The second terminal point is indicated in the proviso to clause 3.
Yes.
That again refers to the recommendation of the Constituent Assembly.
Correct.
Interestingly, 370 is silent on what the regime should be once the Constituent Assembly is formed and has taken a decision.
Which is why two views.
There's complete silence.
Yes.
Right?
Yes.
If there is complete silence in Article 370, then 370, possible interpretation, has worked itself out both in relation to clause 1 and in relation to 2 and 3.
That's a possibility.
Right? In which case, once that happens,
yes,
then we have two options.
Yes.
Your line of thinking would be then, but therefore then the constitution of the state of Jammu and Kashmir will fill in the void, and that will trump, and that will be the supreme document.
Yes.
The other view possibly is, can the constitution of a federating unit ever rise above the source of the federating unit? Because we've always sort of presumed, because, the COs sort of led us up a certain line of thinking.
Yes.
That may have been done. That may have, we're not saying at all that was unconstitutional. It would be very, very improper. I mean, not improper, but obviously these are statesmen who have operated this nation for the last 70 years. And we shouldn't say that, well, they did something which is unconstitutional. They did that to sort of further the course of governance in the nation.
But the judgment in Sampath.
They did that to further the course of governance in the nation. But if the terminal point of 370 is the Constituent Assembly's work,
yes,
then is it not necessary that the work of the Constituent Assembly of the state of J&K has to be embodied in this constitution to make it operational?
It's not necessary, because it's not provided for by the constitution. The constitution looks at the Jammu and Kashmir constitution.
It depends on what view of our federation we take.
Yes.
And if that is not so,
yes,
then is it not also possible to a construction, then where was all this exercise necessary? Abrogation and everything.
Yes.
No, abrogation postulates that it continues. Could be, yes, as we ourselves said, that they applied 370 even post 1957 by all those COs.
Correct.
But if 370 works itself out.
No, if it works itself out, I'm with your lordship. I think we must rethink all these different ways of looking at it. But if it works itself out, it can't be touched thereafter. It's worked itself out. It exists in the constitution.
No, it doesn't exist in the constitution.
No,
it's a provision.
Really on the text.
No.
Without being able to be touched.
Completely. But the text, it is there in the constitution.
Yes.
But it's a provision of the constitution which itself points out its self-limiting character. Right. So it's not obliterated. But if the text itself shows its self-limiting character, then the very operation of 370 has to come to an end once the Constituent Assembly of the state was formed. And that is a key reason why both 2 and the proviso to 3, that you are in a way possibly right. I mean, we'll have to, of course, when I say you're right, it's part of the process of reflection. We have only finished half the arguments in the case, on the angle of finishing half the arguments. That the proviso to 3, when it speaks of, it doesn't say, what does it say?
Necessary.
Declare that this article shall cease to be operative or shall be operative only with such exceptions or modifications.
Yes.
This exceptions or modifications finds expression in 2 parts of this Article 370.
Yes.
Clause D.
Yes.
D refers to subject to such exceptions and modifications.
Correct.
As the President may specify.
Yes.
The second is clause 3.
Yes.
Shall be operative only with such exceptions and modifications as he may specify.
Yes.
So, if you see A 238 will not apply. If 238 applied the part, it was part 6 of the Constitution.
Yes.
Part 6 of the Constitution dealt with the executive, the legislature, the governor, the high courts, and the subordinate courts. There were 5 provisions of part 6.
Yes.
That will not apply. If that will not apply, what would apply? It can't be that there was no executive, governor, legislature, high court, or subordinate courts in Jammu and Kashmir. 1939 arrangement would apply. All right, that's an indication of its being a very pro-tem sort of a measure. Then Parliament may modify. Parliament may make laws with respect to those which are covered in the instrument of accession.
That's describing power of Parliament.
For Parliament.
Yes.
Then such of the other provisions of this Constitution, then comes Article 1 will apply.
Yes.
Right? Then D says such of the other provisions. Now, which are the other provisions? Other than what is stated in clauses A to C.
Yes.
That is 238, power of Parliament to make laws, Article 1.
Yes.
Such of the other provisions will apply with such modifications and exceptions that the President may make.
Yes.
All right? No such matter which pertains to the clause 2 will be made unless, it has the concurrence of the state.
Yes.
Then why does 2 come in? 2 comes in that in case the consent was given before the Constituent Assembly was formed, place it before the Constituent Assembly.
Yes.
So terminal point of clause 2 is the Constituent Assembly.
Yes.
What does 3 say? Notwithstanding anything in this article, notwithstanding not anything in the Constitution, but in this article, the President may declare that this article will not apply, not any other provision.
3 in my view, overrides 2 and 1.
Absolutely.
3 stands right at the very top.
Because of the notwithstanding,
Which is why,
non-obstante clause.
1952 order for a minute.
Right. So that
In terms of 3.
Right. 1952 order, therefore, was the only order before 2019 which applied clause 3.
Correct.
The point now is this.
Yes.
That is there not intrinsic evidence that 370 itself is self-limiting once the Constituent Assembly has come to an end?
As far
And
as we
if
are
it is
concerned, 370
self-limiting,
clause 3 comes to an end with the Constituent Assembly. That's our argument.
but then the point is this. Then do we say that our Constitution must be so read to treat the Constitution of J&K as an overriding document which will apply in preference to our Constitution?
Because if you see the Constitution of Jammu and Kashmir, it differs to the Indian Constitution.
Absolutely. You're absolutely right.
It only
In
makes
which case-
small nominal changes. And
In
all
which
its-
case,
yes.
really speaking, though the Constitution of J&K framed its relationship with the Union of
Yes.
India,
Yes.
unless that relationship was embodied in the Indian Constitution, how will it bind the Dominion of India or the successor parliaments or the executive here?
For the simple reason that when the Indian Constitution specifically recognizes a Constituent Assembly for only one state in the country and says that Constituent Assembly has the task of deciding to abrogate the clause or not. The Constituent Assembly and its task, which is described in clause 2, is constitutionally recognized. So the fact that there is a constitution coming at the end of this is an obvious corollary.
Does that mean that therefore anything that was said by the Constituent Assembly of J&K would bind the nation, bind Parliament or bind the executive here?
It couldn't.
It had to be embodied subsequent to 1957 in a binding arrangement reflected in our constitution, which was never done.
That, my lords,
Because everybody started working on, a working arrangement. The idea was to sort of, gradually bring J&K into the mainstream. Therefore, they didn't want to do that.
which is thankfully what has happened, and which is why if we take the extreme position that there is no question of 370 subclause 1 continue after 1957, Lordships, sorry.
Shankar,
370 clause
340 will, now I think 340 we will finally wrap up and give them 20 minutes to start opening the
not
debate.
anything that has been said before, which is why I'm saying it. So I in fact abandoned this interpretation of 370 except to say one last thing. 370 clause 3 says president may. So 370 clause 3 need never have been operationalized. Please note that. If the recommendation didn't come from the Constituent Assembly at any stage, then the president would have nothing to decide a recommendation on. So while the Constituent Assembly was on, if 370 clause 3 sat there quietly in the waiting room and was never called in, and then the Constituent Assembly went after the Constitution came in, 370 clause 3 would expire there without it ever having been operationalized, because it's a question of may, necessary, recommendation, Constituent Assembly. With those four absent, there's no question then of it being operationalized. But your Lordship's question on Jammu and Kashmir Constitution being recognized here, the Jammu and Kashmir Constitution refers to the Constitution of India as it goes through its avatars. That's in the definitional clause. There are several articles that refer to the Indian Constitution. All the COs that came after 1954 and including 54 refers to the Constitution of Jammu and Kashmir. So as Mr. Subramaniam said, there is a bridge, and that acknowledgement is there even in correspondences which have been shown to that extent. But the answer has to be no. If your Lordship's question is the Constitution of Jammu and Kashmir referred to in the Constitution? No, it's not. But it's understood that it's there. It's a classic federal situation like in the US, where states have their own constitutions, flags, etc., etc. Yeah, that's. Now, the next point, my lords, page 8. This is the earlier attempt to abrogate Article 370. If your Lordship sees, this is to omit Article 370. Just a couple of paras. This is on the right side, if your Lordships will see Sri Nanda, right side column at page 8. He's the Home Minister at that point. And let me just show your Lordships after the extract, and this extract is important. I don't know if your Lordships were shown that 368 has a proviso in its application to Jammu and Kashmir. Now, because of that proviso, I have to differ a little bit from Mr. Sibal's interpretation. When your Lordship asked what are the ways they could have done it if they didn't adopt 370 clause 3, my response on that day and this is 370 subclause 1D is the only way they could have done it, by following the procedure under 1D. What they would have to do under 1D is as follows. First, they would have to get rid of this proviso under 368, because the proviso requires that every time India's constitution is amended.
They have not done it. They have not done it.
They haven't done it.
No. If they do it, we'll see how it is to be tested. That's all.
Yes. But the reason why I'm giving the solution to the government.
You're not an advisory jurisdiction to tell them how to do it, how not to.
I know. But the reason I'm telling them, I need to tell them how to do it, not for my sake or theirs, but to satisfy the conscience.
What they have done is correctly done or not.
I agree.
We are not here to give them advice as to what
they think they can't do it. Yes. We will determine could they do it or could they not do it. At this stage, if they need your advice, they will ask you whether to do it in another manner.
Very well. So he won't, I may. The reason is that it troubles your Lordship's conscience, and I can understand why. If there was absolutely no way of totally integrating Kashmir with India, that was never at all considered. There is a legitimate way. They know what the legitimate way is.
That's it. Happening over a period of time. COs have been issued.
And it will come to its logical conclusion.
The further movement of the remaining assimilation could have been done by this method or not. That's all we are testing.
That's exactly what we're saying. And that is why Mr. Nanda gives the reasoning. Next page, if your Lordship sees page 9. This qualification or this proviso, which excludes the scope of amendments to 370 without certain steps having been taken under 370 itself. We cannot amend the Constitution. Those steps have not been taken, and therefore this bill will suffer from an inherent disability. This may be taken up later on if need be and if necessary, but apart from this, I can leave the rest of that. Next para, this is important. The position is this: while the rest of the contents of the Constitution to which I have made reference negate the application of the provisions of Constitution to Jammu and Kashmir, some of them by extension, others directly. The only avenue of taking the constitution into Jammu and Kashmir is through the application of the provisions of Article 370. That is the only way of bringing back the constitution in J&K. That is my reading of the constitution. Then the sentence about the tunnel, and I say, may I submit to him and the other friends that Article 370 is neither a wall nor a mountain, but that is a tunnel. And he explains further that at the bottom of the page, why he thinks 370 is beautifully conceived, etc., etc. I won't spend any more time on that. On the next is my interpretation on 370. There are a few tables which are annexed to it. The first is with reference to temporary. If you click on table 7, Malor, it shows all the temporary and transitional provisions as on 26 January 1950 in part 21 of the Constitution. I've included those which have subsequently been repealed by the 7th Amendment. But all of these, and the second column shows which are temporary, which are transitional. The head of the chapter, if your lordship may note, initially said only temporary and transitional. Special came later by way of an amendment. So it wasn't there initially. They were only temporary and transitional. And these are the provisions. Your lordship can go back to top. Also, because I think perhaps we shouldn't pay too much attention to this marginal note and temporary troubling us, because there are many provisions across the Constitution outside of Part 21, which are also temporary in nature, which is in Table 8. And the last column in Table 8, if you click on Table 8, the last column shows what those provisions are predicated on until a law is made by Parliament, etc., etc. For example, appointment of the Election Commission, your lordships found that there was a void, and until a law is made, your lordships provided a mechanism. Now the government realized that mechanism should have come much earlier, so they've made a law. The time periods, just for a minute, if you see 334, Article 334, Anglo-Indians, their reservation has come to an end. 70 years has been substituted and remains substituted, but for the SC/ST, they made it 80 years. So that's a temporary provision. It was allowed as long as those extensions existed. I won't spend any more time on that, but just to say that when your lordship look at...
73(2) is not a temporary provision. These are not Article 73(2), these are not temporary provisions. These are provisions which will continue unless varied by any law of Parliament.
Correct.
But these are not temporary.
Unless an action is taken. So, similar to 370 Clause 3, where the action had to be taken by the Constituent Assembly but didn't happen. Similarly here, where Parliament has to make a law but doesn't make a law, it becomes predicated on an action by one of the instruments. That's all. So we are pointing out that the other parts of the Constitution, like when you say 70 years, there's no doubt. It initially said 10 years for the reservation. So that 10 years is temporary. Otherwise, they wouldn't put a time period on it at all. I shouldn't give them more ideas, but they shouldn't put a time period on this. The reservation would go on forever. So the marginal note, Keshav Nanda's 4 judgments we have put there, which show that marginal note shouldn't really be used as an aid. This is only on the temporary part of it. Then, if your lordship sees para 2 on page 10, I've referred to table 1, which are the constitutional provisions applicable to Jammu and Kashmir. Just for a minute, if you click on that, I'm just rushing now. This is, your lordships have it on the screen. This gives you an example. The ones in green are the important provisions relating to Jammu and Kashmir. So the first column is the provision of Indian Constitution. Second column is that which was made applicable to Jammu and Kashmir with what modification. And the last column is the supplementing provisions of Jammu and Kashmir Constitution. It makes a very important reading because there are a few topics on which they had exercised their rights to have exceptions or modifications. Those are the ones in green: territory, permanent residence, property rights, fundamental duties have not been adopted there. Directive principles, they have what seems to be a more robust set of directive principles than we do in their constitution. Lok Sabha representation, services, consent for 352, 356, 358, then 367 and 368, and Schedule 7. These are broadly the ones in green. This is 60 pages, this document. My associates spent a lot of time going provision by provision of all three. to make sure that it can be an exhaustive table that's set out. If your lordships come back to the note, my lord, consultation and concurrence. Now, these phrases are used elsewhere in the Constitution. And it can't be that for purpose of 371D, where the impure notification has come, that you've treated it so casually. Because there is a particular purport and a direction when you seek consultation and you get concurrence. In the demonetization case, Justice Gawai was part of the bench, and speaking through him, para 245 talks about the different types of consultation. These paras are set out. I'm not reading them. Second is the consultation which your lordships, in as far as appointment of judges in both SCORA as well as the special reference, you've read consultation in a particular way. So there is a meeting of minds. Now, it may not be the 124 interpretation that you have to have, but you have to some basic meeting of minds, as with the RBI in the demonetization case, as between the collegium and the government here, a certain meeting of minds. That meeting of minds doesn't mean your mind meeting your own mind. It has to mean some entity outside of yourself. You can't, by this device of 356, say, what do you think about this? And then tell yourself, oh, it's a great idea. Somebody else has to do that for you. And that's what they have sidestepped. And they've done it in the Constitution, which is why it's shocking. This is not some order by an executive of hearing. This is a constitutional amendment that you've effectively wrought about by way of this device. In Article 338B9, which deals with the OBCs and the commission required for that, your lordships in the Maratha reservation case said that the consultation there is mandatory. When you decide to add the Marathas to the lists, you should have consulted, you didn't consult. Now, all these are examples of where else in the Constitution you have consultation and what it means. And you're weighed in Constitution bench after Constitution bench, up to 9 judges, repeatedly you're weighed in to say this is what it means, this is the meeting of minds. That's completely thrown overboard by what they have done. Importance of the proviso, I've mentioned these 2 judgments, Quixote and Rajendra Shah. Colons, the Indoor Development Constitution bench, links the proviso to the main provision, so there's no question about that. Recommendation, we have a table on recommendation, etc., which is table 6, which shows the many places in the Constitution where the word recommend is used and what its implications are. And it's necessary because it provides a kind of balance. A recommends to B. B can't set up A to recommend to B. A independently recommends to B. And that's also been thrown overboard. The non-obstante clause in Article 370 is very, very important. This non-obstante clause effectively trumps the other provisions in the Constitution which don't have non-obstante clauses. 356, 367 all don't have non-obstante clauses. Now, why does 370 say notwithstanding anything in this Constitution? It is so that in a situation where any of these other provisions could be in conflict, 370 is the one that will prevail. Which is why we have set out what those provisions are. The first bullet point talks about to Article 3, that proviso, which is in the if I can show in para 8 on page 15, just how Article 366 was misused in Madhav Rao Scindia. 367 is being misused here. Just see, 367, you please note, falls in part 19, my lords. So it's not covered by 368(2) proviso. So everything in 368(2) proviso, which needs half the states to give its consent, they can do by way of 367. Just say for each of these articles, this provision will read thus. Examples. The word person in Article 21 can be interpreted to mean person accused of an offense. In 367, I'll put an interpretation clause which says person in Article 21 will mean person accused of an offense. So all other rights that your lordships have read into Article 21 is out of the window because it's only person accused of an offense. Why? Co-location. It's right next to Article 20. It's 21. So it's similar kind of people. That's the justification they could give if we allow this to happen. Using 367, the phrase the legislatures of not less than one half of the states in the second proviso to 368 could be read as the Rajya Sabha or the law minister. You could say that. We followed the right procedure. We followed a procedure of doing it by way of 367.
Giving all these ideas, Mr. Shankar Nayak.
Which is why, please take a sledgehammer to this invidious method of trying to subvert the constitution. And the reason why I say this is because Justice Hidayatullah and Madhav Rao Scindia says we must take extreme examples to test what they are doing. Only when you take extreme examples, he talks about the Maharaja of Sindh and says, suppose the Maharaja of Sindh is now said to be the Nizam of Hyderabad. Of course, the president would never do anything like that. But we must take extreme examples for this purpose, which is why I'm forced to take these extreme examples to show that if they're allowed to do this, heaven knows what they'll do next. Now, I won't read the next bullet point for many reasons. Your Lordship may read it on your own. If your Lordships come to page 17, frauds on the Constitution. Ordinances, 3 judgments on that, Wadhwa, A.K. Roy, and Krishna Kumar Singh, my Lord's Justice Chandrachud's own judgment. In fact, A.K. Roy is the other Mr. Justice Chandrachud's judgment. We have put both those extracts there so your Lordships can see. In fact, both your Lordships have spoken in very similar terms about how the Constituent Assembly held forth, as it were, an assurance to the people that an extraordinary power shall not be used in order to perpetuate a fraud on the Constitution, which is conceived with so much faith and vision. That assurance must in all events be made good. Your Lordships have said, an edifice of rights and obligations cannot be built in a constitutional order on acts which amount to a fraud on power. This will be destructive of the rule of law. Similarly, in precedents rule, how abuses are done, S.R. Bommai's paragraphs, Rameshwar Prasad, privy purses, I'll read separately in a few minutes. Possible consequences of such abuses, if you see point 5 at page 19, there's a separate table on this, where we have substituted legislature of the state with parliament everywhere in the constitution, so you can see how absurd it becomes. Because by using powers under 356, can you do things which are irreversible and destructive? The idea of 356, much like 123, is a stopgap. It's in between. So that eventually Parliament or the government will take a call on it. It is not that you can do something completely irreversible and say, sorry, I had the power to do it. You didn't. Votes on accounts, GST, procedure of legislatures, panchayats, municipalities, even 246. Where list 2 is with the state legislature, Parliament can say state legislature is Parliament and then start making laws on its own. Surely that is not what is envisaged. Federalism and Article 3 has been exhaustively covered by Mr. C.U. Singh. I've just put some extracts of both the GNCTD cases, particularly to show that the GNCTD 2 is one that is, I think, very, very clear on the unique position. And one small thing at point 2, page 22, second point, 12 reorganization acts have been enacted. We have given that list, that's table 4. This is 2B, my lords, bottom of page 22. 12 reorganization acts enacted till date show that a state has never been annulled. The first one is this, where by way of this Kashmir Reorganization Act, entry 15 has been deleted, everything has been renumbered and moved up one. It's never happened before. All that's happened is union territories have moved into the state list. That's all. You've never had a situation where the converse has happened. This is the first. Malod's Mangal Singh, Mr. Singh referred to it. Mangal Singh effectively said that states must have legislature, executive, judiciary, etc. And all of these must be in existence. By going ahead, not following the procedure with reference to legislative council, we've heard that point already. So I'm not referring to that again. Yes, Mangal Singh is reiterated in Keshavananda Bharati. Your Lordship may see that. That's also
pointed it out.
Yes, yes. And point 4 at pages 25, 26, the irreversible effect on states' rights under the Constitution, points C, D, E, and F, Mr. Nafde made. A, B, G, and H is what we are canvassing. I just want your Lordship to chew on one point. If this were permitted in an Article 131 suit, which say the state of Punjab files against the Union of India, the Union of India will impose President's rule on Punjab, be on the other side, withdraw the suit and disappear. Article 356, the manner of the exercise. Those SR Bommai paras have been extracted, my lords. We have given an illustrative list, which is now in my written submission, the original written submission. I mentioned it here at page 28. Para 26 of the written submissions, which lists all the possible misuses that are possible under this. And one important point, my lords. What is permitted under 356(1)(a) is only for the functions of the government to be taken by the president. Functions, not powers. Now, what is provided in 370 is not a function with the greatest of respect, it's a power. 356 didn't permit it. Their proclamation under 356 is in the same terms, it says functions. So the only thing that could have been taken over was functions, not powers. So this was a power, and they have taken over what effectively is a power, and they've utilized it. I think this is an argument that they must meet. They must explain how possibly this was a function. A function under 356, which is temporal, is something which is a day-to-day activity which needs to be done. It's not a discretion which has not been exercised in 70 years suddenly becoming a function. I have pointed out how irrevocable changes cannot be made. And the last point, I've given your lordships the details of the judgments, the amendments, etc., dealing with Pakistan, Gilgit-Baltistan, as well as what they call Azad Kashmir. And hopefully we will not tread down the same path. I just want to conclude with one last thing, which I have set out. That's already been done. Which, page 16. This is Vattel's Law of Nations. It's a very, very old book. I'm grateful to Mr. Rahul Narayan who lent it to me. It's in fact one of the oldest books on international law and laid down the principles. George Washington didn't return his copy to the local library in Philadelphia, and they discovered it 200 years later. Now, if I can just read 2 paragraphs of this, it's set out at page 16. I'll just read that because I think it's important for us to bear in mind. Para 30. The constitution and laws of a state are the basis of the public tranquility, the firmest support of political authority, and the security for the liberty of the citizens. But this constitution is a vain phantom, and the best laws are useless if they be not religiously observed. The nation ought then to watch very attentively in order to render them equally respected by those who govern and by the people destined to obey. To attack the constitution of the state and to violate its laws is a capital crime against society. Please note this. And if those guilty of it are invested with authority, they add to this crime a perfidious abuse of the power with which they are entrusted. The nation ought constantly to repress them with its utmost vigor and vigilance as the importance of the case requires. And then, para 35. But in treating here of the change of the constitution, we treat only of the right. The question of expediency belongs to politics. We shall therefore only observe in general that great changes in a state being delicate and dangerous operations, and frequent changes being in their own official, a people ought to be very circumspect in this point and never be inclined to make innovations without the most pressing reasons or an absolute necessity. The fickleness of the Athenians was ever inimical to the happiness of the republic, and at length proved fatal to that liberty of which they were so jealous without knowing how to enjoy it. My lords, in Mother House India, I'll just give your lordships the paragraphs. Please
said that twice or thrice at your own leisure, but have you left us any after this comprehensive?
I'm so sorry, I don't want to take more time.
Comprehensive, no, absolutely.
Not even leisure for now, for the next couple of months.
I'm so sorry.
But
your lordship,
we must compliment you and thank you and your juniors as well for putting this together, because this actually puts very. I was just telling Brother Sanjeev Khanna, very.
Assisted
Please tell all your
names are put there in the written summary, but they've been most.
You've put it all together, so it makes our task so much easier than to constantly cross-reference.
I'm grateful. But just if your lordship can note, Justice Shah, this is at PDF page 448 is where Justice Shah starts, speaking for 7. He's joined by Justice Hidayatullah earlier and Justice Hegde later. paras 94, 111. Then Justice Hegde, who says it's fraudulent and for collateral reasons at 173 and 176. Should I repeat those? 173,
You put it in the note.
No, that's not in the note. That's why I'm so sorry.
Just one second.
That's not
Just
in
come
the-
again then. This is Madhurao, right?
Yes. Justice Shah, paras 94 and 111. There's lots more, but I'm just giving you what I think is the most.
94 and 111.
Yes. Justice Hegde at 173 and 176. Paras 173 and 176. And Justice Hidayatullah at paras 42, 53, and paras 73. 73 is where he says extreme examples are necessary to solve extreme cases. Because I believe this is an extreme case, mainly because of the way they have conducted themselves. I'm most grateful for the patient hearing you.
So just a little announcement. One second, just a little announcement for next week. For next week, we will commence the. Of course, we are sitting tomorrow. Friday will be miscellaneous, but next week onwards, to ensure that we complete the hearings in continuity, we'll be sitting on Monday as well. So the Constitution Bench will be assembling on Monday in the next week.
Just one thing, I made a small error in my oral arguments yesterday. It doesn't change the argument. I said the explanations would not apply in Article 3 to Jammu and Kashmir because they were never extended. But if your lordship were to uphold CO 272, which came on the 5th, then with that upholding, those explanations as well as the proviso which applies in the Constitution of India, all three would then apply. But it doesn't change my argument. My argument remained the same, that unless both houses made the recommendation, the bill could not be tabled at all. So that argument remained because the second house did it only on 6th. Just factually, the explanation would apply.
Tomorrow we open with the. How will we be opening tomorrow?
Division of labor among us.
That will, my lord,
yes.
intimate
And we indicate your lordships with some opening note, and then we have divided our work on some respects.
So there'll be no overlap then between you.
Indicate tomorrow morning.
And basically, on your side, it will be the Learned Attorney General, the Solicitor General.
First, Mr. Salve, Mr. Jetmalani, Mr. Guru Krishna.
Of course, the attorney, you and the solicitor will complete first.
Mr. Natraj and Mr. Vikram. But we have, my lord, realistic time assessment, my lord.
And the attorney and the solicitor will argue the lead case first. Then after you both are done, who will argue thereafter? Mr. Dwivedi.
Mr. Salve.
Then Mr. Salve. All right, give it to us. So we just have the aid memo here tomorrow.
Lord, by evening, we'll, my lord, Mr. Sanjay.
Between attorney and the solicitor, broadly, how long do you both anticipate you take?
It's like I propose to give my opening summary of arguments, and then a good part of the history and other things solicitor will continue. And then I'll come back and try to respond to the major legal submissions. That's how we have divided the work.
So tomorrow, in the opening, how long would you take about?
I'll take about 10-15 in the opening. Then
fair enough. About just
cover on the entire historical background and other things like that.
Then solicitor will cover the rest of it.
Thereafter, the legal point in the summary, I'll come back and that's how we have divided the work.
And then Mr. Dwivedi, what's the Mr. Solicitor, how long would you take? Will you wrap up tomorrow or you'll be spilling over to?
It will spill over. It will. Right.
So should we? How much time on Monday do you anticipate?
I think Monday.
All right. So by Monday evening, then the attorney and the solicitor, between the two of you, I think you can both be covered. I mean, of course, these are not hardened.
Hopefully, my lord. My lord, I'll ensure that nothing is repeated.
No.
But some of the
obviously by now you know that these are not hard and fast, but we're just having a broad estimate.
Some of us on this side, my lord, have substantially bored your lordships. Your lordships would find some of the judgments name familiar, but the relevant paras, my lord, were missed. Therefore, my lord, we may have to read it. And only unavoidable repetition, my lord, would be there. Otherwise, we'll ensure that there is no repetition.
Any estimate, Mr. Dwivedi, how long you would take after? It depends on what they cover, but roughly.
They cover the field, it will get reduced. I hope for 2 hours. Then if your lordships are Please to give me 90 minutes. I'll be.
Has Mr. Salve indicated how long he would take?
Malad, he said, Malad, he has said 1.5 days, Malad, without knowing about the earlier Malad part. But
Lord, I take 1 hour. Not of 1 hour, but I will restrict myself depending on what will be covered.
Mr. Natraj has said 45 minutes.
So we can ask.
Mr. Jetmalan is there.
Give a list.
Very opposite.
What's it?
So we are just sharing, Malad, this is not the list prepared by us. So prepared by
What's it list?
time. Chai. Sanjay, email to. We have emailed. You can
Have the time.
But this is the estimate Mr. Kanu Agarwal received, Malad, from various councils.
Is that when the whole case is opened so many times,
Yes,
ultimately you are giving your propositions.
correct.
Of course, as you say, perspective in a judgment, or perspective maybe in some fact scenario is what has to be done.
Or some of the judgments not read or not fully read, etc.
For instance, personally speaking, I think it's a little overestimate, I find, of time. But
Lord, we are in a lordship sense, Lord, we ensure
I think once the first two arguments are concluded, then perhaps the rest would know how much to take. I
yes,
think,
yes,
and then
we'll use that
yeah.
discretion, Lord, all of us would use that.
definitely.
Yeah. That's it.
Somebody is given from this his own estimate of time as if he's arguing. This is my perspective of this.
Mr. Banerjee has given a day.
My lords, IST is Indian stretchable time, but we will keep it as Indian standard time.
The chief is far more patient.
Well, that is
Good.
obliged.
So,